Yes.
Maybe I should take back to mention item number 3, maybe.
Item number 3. Yes.
I need some instructions in this case.
Okay. Mr. A.R. Delucid and counsel for the petition has submitted that as he needs some further instructions, the case be posted after
Next week, maybe.
a week. Posted.
Bless.
As spread for the place the case after only 2 weeks by hours.
Bless. Wait, please. Item number 25. This kind of senior counsel submitted. Senior counsel submitted.
Mr. Yes. You are for the respondent. Your name?
J. Das.
On the prayer of Mr. J. Das, learning counsel for the respondent number 2. Which praise me to the considered learning counsel for the petitioner. And the learning counsel proceeding to place the case after.
Can it be on 5th of August?
Who has got it by order?
I have mentioned. I'm for the petition.
If I wait.
Please, Lordship. Let's say back to mention item number 9. So, matter may be adjourned for the day, Lordship.
On the prayer of Mr.
B. Borgohai, Lordship.
We were highlighting the for the petition. The case is possible for the thing.
Master.
PP. RJ was present. What must be give that?
Appellate on the first I get some mention for listing one criminal petition. Yes.
Motion.
Yes, sir.
Motion.
The admission. No, sir, another password for the item 53. Password.
You are Mr.
M. Rahman on behalf of Panam.
And Ahmed. The prayer of Mr. M. Ahmed learning counsel for the appeal stands adjourned for his vote.
I beg to mention item 44 of today's basis. The matter may be kindly passed over for the day. Some difficulties today. 44.
On the prayer of Ms. F. Hussain, learning counsel for the petitioner. The case is passed over for the day. PP.
Obliged.
P. Bulwa. On the 31st what? July. On the prayer of Ms. Guru and counsel for the petitioners. Come on, we'll leave the case on showing submit. Miss, who is there? CBI. Miss? Angel and counsel for the CBI is present and has agreed to the posted date. Playing game or suggestion for the until the next day of this.
May I please, Lordship, I beg to mention item number 7, Lordship. The engaged counsel is unable to appear the court today, Lordship. So, Lordship, kindly adjourn the matter after 1 week.
Okay, on the prayer of Miss
M. Deca.
M. Dekala, counsel appeared for a petition. The case is adjourned for a week. PP.
Please, Lordship.
I give it to the court.
The Lordship, I beg to mention item 48. The matter may kindly be adjourned for 2 weeks.
48.
Mr. Lordship.
Yes, what is your prayer?
Matter may kindly be adjourned for 2 weeks.
Okay, Miss
Miss N. Yepto on behalf of Mrs. K. Devi.
on the prayer of Miss so and so. land council paying for Miss KDB land transport petitioner. The case is adjourned for 2 weeks. Submitted and considered and taken from the land condition officers. Make the pay.
May I please your lordship? I beg to mention item number 22, lordship. There's some difficulties, lordship. Kindly pass over the meter for 1 week, lordship.
You are for a petitioner or
Yes, lordship.
your name, please?
S. Sud.
S.
Sud, behalf of Tisho.
It is possible for the week. It is submitted that consent is taken from the land for the respondents to make a prayer.
Unless,
30? Yes. What is your prayer? What is your prayer? Adjourn for a day. Your name, your name. Mr. Islam, possible. Let's make a prayer for adjournment. Was the submitted and considered been taken, but other prayers from this prayers, but pray the Lord is the case. The case is possible, as paper, case is possible.
May it please the lordship. I beg to mention item number 28. But in this case, I appear on behalf of the petitioner, Lord. We would like to have some instructions on that, Lord. They have filed an affidavit, Lord. It did come after 2 weeks.
Or do we, how much time?
2 weeks, Lord.
Or do we land council for the petition? Submitted that the LC needs to obtain certain or obtain further instructions, the case will be listed after.
The friend is there.
They submitted that consent has been taken from us. So.
He is present.
Mr. Ardhor, ED, then counsel for the respondent ED, is present and has no objection to a secretary. As been paid for, please the case after this.
Deeply.
This matter. In the matter relating to the seeking custody of certain articles, this is very investigating of this man. The last occasion, while police report was called for. So police report has not yet received. So on
Yes, Mr.
item 30. 30. So let this matter list after.
Okay. FKR Amil and counsel for the petition and Mr. Ajay Burwell and additional public secretary for the respondent states are present close to. This additional public secretary is supposed to obtain a report from the IO. First of, as the report has not yet been received, lays the case after a week. As sought for by the land council for the parties.
So I can date may be fixed by rather right.
Correct.
One.
May please, lordship. I beg to mention item number 11, my adjourn for the day, my next week.
11. On the prayer of Mr.
Why are you?
Y. Ali, land council for the petitioner. The case is adjourned for a week. Consent.
Please, lordship. I wait for list 2 criminal revision petition for admission by next week.
Admission. Criminal appeal for what? Admission. Why? It is not admitted, criminal appeal. Criminal appeal is ordinary to be admitted. If it is criminal appeal. Did you?
May I please your lordship, item number, I would like to mention item number 29 and appearing on behalf of respondent, 2 weeks time may be granted for filing objection.
Who is for the petitioner?
I am appearing from respondent
You are Miss.
as does on behalf of P. Mishra.
You have informed the other side. And informed the other side. IA for what? Side you.
May I please, your lordship, I beg to mention item number 26, my lordship, Mr. Arguing counsel, Mr. B. Bora has left for Delhi yesterday. His father is terminally ill, my lordship. Can it be adjourned for 3
Your-
weeks, my lordship?
Mr.
P.S. Raja, my lordship.
And have you informed the other side?
My lordship, yesterday only he left. We could not procure the consent, my lordship. During the course of the day,
Get
we,
the consent,
my lordship, during the course of the day, we'll inform them, my lordship. If kindly, my
because
lordship.
you are seeking adjournment for 3 weeks. He may have some objection, kind of.
Thank you, Lordship. Lordship, I did mention item number 24.
20?
I'm-
4.
Yes, Lord.
Yes.
I'm for the petitioner, Lordship. On last occasion, I was directed for the instruction from my client, but I could not contact with him since.
On the prayer of Mr. S. Islam or R. Islam, learned counsel for a petition and the case is adjourned for 2 weeks. It is submitted that, yes,
Maintenance has been awarded from the date of judgment, my lord. He is not paying anything, my lord.
Hmm,
I am moving.
okay. Mr. H. Ahmed, learned counsel for the petition, respondent is present, also as sought for and agreed to by the learned counsel for the parties, leaves the case on suspense.
So that will be given. Lordship, I am the day, Lord. Lordship, I will withdraw my follow from lordship since I could not contact with my
We file an application before that, not before this court, orally.
client.
May I please, Your Lordship, I beg to mention for listing of a criminal petition for orders for Friday, my lord.
Not
My lord,
Friday.
Well, NBW and proclamation is issued against the petitioner, my lord, and Monday is the date fixed before the learned court below, my lord.
Hmm.
And my lord, the honorable court, my lord, without hearing the informant, my lord.
Now, since how long NBW has been issuing by the Ryan Trial Court?
My lord.
And since how long you are avoiding?
In the month of December 2024, it was issued.
So how it, the urgency has arisen suddenly? Next week.
Obliged, my lord.
And appearing on the rise list for, I'm able to appear before this.
Item number 15. Motion. On the prayer of Mr.
A.E. Khan.
A. Khan, learned counsel appearing for the petitioner. Please, the case is passable for a day. Huh? After, okay, case is adjourned for a week.
May I please, Your Lordship? Your Lordship, I beg to mention 2 criminal petition for listing, Lordship, in orders column. Can it be
Give
on
it to-
Friday, Lordship?
No, give it to the court master.
May I please, the Lordship? Lordship, I beg to mention for listing, my lord, of criminal petition number 869 of the 25, my lord. My lord, case has been registered 17/7/25, my lord, but it has not been listed.
Motion?
Yes, my lord. Tomorrow fixed, my lord.
Maybe defective.
No, my lord, already case registered, my lord.
Okay,
Case number
Friday,
tomorrow.
Friday.
Potentially yesterday, the case was listed, but probably,
Okay, did you for next week or did you?
and next week, Lordship Monday.
Next week we'll see.
May I beg your lordship? Lordship, I beg to mention the 2 criminal petition matter. It was one is for listed on 12th June 2024 and one is on 11 March. Kindly be.
Give it to the court master. He will accommodate.
Lordship, with regard to item number 26, I have taken the consent, my lordship.
Okay, Mr. T.
Yes,
S. Raja, learned
yes, sir.
counsel for a petitioner, comma, with a consent of learned counsel for the respondent, comma, have made a prayer for adjournment of the case, for 3 weeks. And
Highly obliged, my
so, very about this, the case of 3 weeks, on a date 3 weeks by the office.
highly obliged, my lordship.
Release for withdrawal. Item 1.
May I be? This matter has been amicably settled, my lord.
Okay, Mr.
K. Uddin.
Uddin, learned counsel for the petitioner has submitted that as the issue between the parties have been amicably settled. The petitioner does not want to pursue the instant criminal petition. Also, he has thus submitted on instruction. He has thus submitted on instruction that the petitioner must withdraw this petition. Oh, sorry, criminal petition. You have to have a submission by Mr. Declaring counsel for the petition, the criminal petition is dismissed on the trial.
Okay. One more time. Item number 2.
Yes.
My lord, this is a criminal revision, lordship. We have challenged 3 orders of the first by the landed judicial magistrate plus Murigaon.
She orders.
Yes, lordship, this is a unique case, lordship. By invoking the powers under 107 BNSS, the attachment of the properties, our landed properties have been attached on the plea that it has been proceeds of crime.
Which are the 3 orders?
Lordship, one is 21 to 25.
Page.
Just one. Page is 35, lordship. Then another order 20, sorry, lordship 40.
Page 40.
Page 40, lordship. The other order is page 56, lordship. Annexer 6.
Page 40.
And the final order, the interim orders have been marked with this final order, lordship, on 26,
50.
Annexer 9, page 76 onward.
56. And last order? At page?
Page 76, lordship. Lordship, the case started with 2 FIRs.
Yes.
One is Modavari PS case 178/24 and another is 184. Having allegations of cyber crime. One named accused has been there. We are not neither the named accused. During investigation, police has filed one petition before the court of JMFC lordship. We have annexed the petition as annexer 3 lordship at page 35.
Thirty-five.
35
This
lordship.
is the application.
It is an application by the IO for attachment of the property, lordship. Before coming on the facts, lordship, I would like to draw your attention of your lordship on the 107, provisions of 107, lordship. It is a totally new provision, lordship.
BNSS. BNSS. Yes.
May I read, lordship? Where a police officer making an investigation has reasons to believe that any property is derived or obtained directly or indirectly as a result of criminal activity or from commission of any offense, he may, with the approval of the superintendent of police, this is an important lordship. Please note, sir, with the approval of the superintendent of police or the commissioner of police, make an application to the court or magistrate exercising jurisdiction to take cognizance of the offense or commit for trial or to try the case, the attachment of such property. Then subsection 2 provides.
One minute. Yes.
The subsection provides where the court of magistrates has reasons to believe. This is one aspect, lordship, here. The magistrate before or after taking evidence that all or any of such properties, crimes, the magistrate may issue a notice upon such person. It has been complied with in our case, lordship. Then where a notice issued, any person under subsection, any reasons on behalf of such a person, copy of the notice shall also served upon such persons. It is also been complied here.
Specified any property has been given. Yes.
Then for the court of the magistrate may, after considering the explanation, in any case to so cause notice issued under subsection 2 and the materials facts available before the court or the magistrate after giving a reasonable opportunity of being heard. This has been complied in our case, lordship. Provided that in such person does not appear, it is not the case, we have appeared and contested. Notwithstanding anything contained in subsection 2 or the magistrate is the opinion issuance of notice under this subsection would defeat the object of attachment or seizure. The court of magistrate may, by an interim order, pass an ex parte direct the attachment or seizure of the property and such order. I am pausing for a here moment for here. In the prayer, lordship, the made by the IO, no prayer for interim order was made, attachment was made, but honorable court find it fit to attach our property on the very first date. It is the annexure 3 at page 35, Lordship. A simple prayer was made by the IO, bringing some allegations that one Sariful Islam is engaged in the cyber crime and he has received a huge sum of money, about 1 crore. So attachment proceeding started, but learned trial court has by annexure 4 at page 40, Lordship. Particularly at page 44 and page 45, Lordship. In the last part, come to a conclusion that there is every possibility that accused is in complicity with several other people's dubious nature and is highly probable that he brought the said properties with the proceeds of crime.
Which part you are reading?
Page 44, Lordship. Last part.
Yes. On Procedural case record.
Yes, the ekdam last 3 lines, Lordship. Last 4 lines. Magistrate has come to a conclusion. At that point of time, no notice was issued to us, no hearing was made, an ex parte order was made for attachment. Then, Lordship, at page 45, next, this second paragraph. As such, the considering the materials on record, submissions by learned PP and learned assistant PP, and also considering the nature of the accusation against the accused, it appears that prima facie materials are sufficient at this stage for this court to believe that accused is carrying an illegal activity. The said property in question is brought by the accused from the proceeds of the crime. So, in the last paragraph, Lordship, I deem it fit to pass an order of ex parte directing the attachment of the land measuring 1 kattha, 5 lesach, and another land measuring 10 lesach.
Okay.
Thereafter, another petition was filed for attachment of the property of the father of the accused Sariful, the petition number 1 here, Sirajal. In that case, in that petition, Lordship, no ex parte order was passed. Finally, on 2/6, Lordship, starting from page 76, Lordship, the final order. After hearing both the sides, we have submitted our so-called replies. I have annexed the copies, Lordship. By order dated 2/6/25, after discussing the prosecution materials and the documents, income tax returns, trade license, etc., what we have submitted in our submissions, Lordship.
Now, what is your ground of check? Basic grounds of.
Basic grounds are totally arbitrary order, Lordship. Without, even today, we have not been arrested. First thing, Lordship, as I pointed out, Lordship, the permission of the superintendent is required.
Is a condition precedent? I don't think so.
Hearing, but permission is a condition precedent, Lordship.
Huh? Permission.
Permission from the superintendent of police. 107, Lordship, subsection 1. Where a police officer making an investigation has been believed, reasons to believe. In their prayer, there is no word even reasons to believe, not to speak about the grounds. Then, with the approval of the superintendent of police, may make an application for attachment of the property.
What is the final order says?
Final order says that been attached.
Anything regarding permission?
Yes, Lordship, at the page 92, Lordship. Para 36.
There are 36.
We have challenged that ground during our hearing also. As such, considering the above discussion, since the accused notice could not satisfy the court regarding their income source and his income was not proved, this court deems it fit to reject the petition. Further, regarding the objection by the accused noticee, stating that IO did not seek prior approval from the superintendent of police on perusal of the case record, it reveals that IO has violated dated 10/2/2202. Sought permission from the SP Morrigan to attach the properties of the accused noticee, and accordingly he was granted approval by the superintendent of police.
So it was there.
No, that's why I'm saying, sir, Lordship, we could not collect it on that day filing of the, subsequently I have collected from the records, Lordship. Wait. What the permission, the 11 2 Lordship. The 10-2 letter of the IO. Therefore, I pray your honor kindly pass an order. This is the prayer of the IO before SP. Last line. To pass an order for proceeding in the inquiry in this regard under for further necessary action as per law. No prayer has been made seeking permission to file and petition for attachment of the property, Lordship. And the
That is not very happily worded.
No.
You cannot expect everybody in.
then come
in
to the
town-
order of the SP, Lordship. Approval to conduct investigation subject to IO.
Under sections 107.
Lord, peruse your letter. Accordingly, you have been allowed to proceed to conduct investigation. That is the specific word here, Lordship. Under
Some-
section 107.
some leeway is to be, some leeway is to be given because this is a new
No,
provision.
way is, Lordship, when the law provides a particular specific word is there, permission from the Superintendent of Police for attachment to making a prayer for attachment. Investigation, there every rights, Lordship. We are not challenging that part, Lordship. For investigation part, making a property, collecting of that
Allowed
data,
to proceed to conduct investigation.
Lordship.
That would change the nature and character of the proceedings of 107.
Without permission, they cannot move the court, Lordship. Here, without the permission, they have moved the court.
No, it is prior to making the application at page 35.
Yes, sir. Yes, sir. Yes, Lordship. Because they have here.
Because the permission, whatever,
On
whatever,
10
you are not satisfied with the wordings.
No
of the
permission has been
SP.
granted, only investigation part has been granted, Lordship. My humble opinion, my humble submission is that, Lordship, only SP has allowed him to make investigation under 107, not to move the code for attachment. When the law requires that no prayer should be made, again I am reading the order, with the approval of the Superintendent of Police, make an application for attachment of the property. For attachment, he must have an approval. For making a prayer for attachment. Making an investigation, okay, it is an internal matter, let them do as they wish. Secondly, Lordship, this is one count, Lordship, legal count. Secondly, case is registered in the year 2024. We have not yet been arrested. As per the data available with me, Lordship, another 30 accused has been arrested from 27/11 to 6/6/25. No other person's property. All are of the allegations of the cyber crime. IO did not find it necessary to investigate or for attachment or for any investigation on the property or accused of cyber. I am not an FIR named accused. I or my parents have never been arrested here.
No,
Thirdly, Lordship,
let us see
investigation
the
still is
application.
going on, Lordship.
Let us see the application. Page 35. No, what is the next stage after attachment? Say, as part of
After
provision.
attachment, say, Lordship, subsection 6. Once the learned magistrate opines that it is a proceeds of crime, Lordship 6, if the court of the magistrate finds the attached or seized properties to be proceeds of crime, the court or magistrate shall by order direct the district magistrate to ratably distribute such proceeds of crime to the persons who are affected by such crime. Here in the first crime, it is registered by police on a basis of secret information, and the second
So it will be the day after distribution.
distribution also. So
Yeah,
now once magistrate has held that it has been proceeds of crime without any charge sheet or any other material.
Mr. Buddha, at this stage, you can issue notice and no further proceedings under subsection 6
Lordship,
should be.
Lordship,
That is the only thing we can
Lordship.
rest to. Yes. Because crime has to be investigated, ultimately charge sheet has to be filed, and ultimately person has to be convicted. It is not that it is a clear case that from this account, only one person, his account was hacked, thereafter 1 lakh was out of that amount and went inside the account of the petitioner. It is not the case. There will be huge investigation.
My photo comes on my lord, this state, my lord, let the case there be called for. Let the case there be called for. Because the order of that's my lord, this is a interlocutory order. It is not the final order.
So no further proceeding, you cannot distribute the proceed.
Sale should be stayed.
There.
Sale should be stayed.
Yes. No, apparently, where is that? You take instruction that whether case has been charged or trial has ended. Sees the language of subsection 6.
That I have gone through. If the court or the magistrate.
Shall by direct the district magistrate to ratably distribute such proceeds of the crime to the persons who are affected by such crime. Have they been identified?
That is the part of the investigation.
No, that is the part of the investigation there of the court.
Yes, that's what, madam. Ask madam that.
IO is not in a position to distribute. Court will distribute.
And secondly, madam, this order is of Mr. Madam 6,025.
You can proceed with the investigation.
It
I'm
is
not
not an
staying the investigation. Otherwise, there cannot be if they sell this property. Can you restore it back?
One sold, multiplicity will start, multiplicity will proceedings will start.
If they sell the property, suppose, can you restore it back? No. Hard.
For that, madam, that's very good.
Where is the FIR?
FIR is at lordship page 21 and 24. There are two FIR.
They are basically challenging the man of the whatever it is, number 170.
No, but that is in March, lordship. We have mentioned here statement lordship. 178 and 184 got marked lordship.
Page 31, who are those?
Page 21 to 34. Page 31 lordship.
No, page 38.
No, according to this FIR has been filed by one Aditya Birla Finance Limited.
Page 38.
Providing loan to
there is a
various persons. We are not no way connected. Lord.
1 minute, 1 minute. I have not read it like
Lordship.
you. I am asking.
No,
This there.
according to police lordship, this person Aditya Birla has
I am
provided loan.
asking a query. Please
Lordship.
have the patience to
Please,
hear.
I am sorry, lordship.
I have not read this brief as like you. Page 30, there is a table and there are names mentioned, right? Who are they? They are the alleged victim or they are the
No,
alleged
Loan have been provided to them.
alleged perpetrator of crime?
These are the fictitious part.
According to
These are
these
fictitious.
fictitious persons, loan has been provided to in the name of
This
this
is what
person.
I am asking.
Yes, Lord.
So as on that victims are not in the forefront. Aditya Birla could be the victim.
Yeah, they are the big.
Heard Mr. S.K. Punta. Learned counsel for the petitioner. And Mr. R. J. Borwa. Learned additional public prosecutor for the response. Petitioner, sir. Respondent state of Assam. Post of. Extend petition under section 434, 520, penalty and report of cabinet. Is instituted, let's say, orders. 3 orders. Dated. '21 to 2025. Annex Roman 4 that page 40. Yes, 46. Comma order dated 7/4/2025. Annex of 5. No, not annex of 5. Annex of 6. Page number 62. An order dated 2/6/2025. Put in again next one line. Page number 66. Passed by the Learned Judicial Magistrate First Class Morigam. On applications filed by the IO of Moirabari Police Station, case number 178 of 2024, and Moirabari Police Station, case number 184 of 2024, under section 107 of the BNSS posted by the impin orders, comma. How many properties?
3 properties.
3 properties. Registered belonging to the 3 petitioners. Belonging to and registered to the name of the 3 petitioners have been attached. Post of Mr. Pudral and Council for application submitted that the the 2 cases are having
Amalgamated, Lordship. Right, order dated
the
21.
apostolated 2 cases have since been amalgamated and investigation is carried out as on date. Post of he has submitted that the condition precedents for submitting an application under section 107 BNSS have not been met in the instant case. Condition precedent laid down in 107 in bracket 1 of the BNSS have not been met in the instant case, resulting in the impin orders being arbitrary. So this is one ground. Second ground,
Regarding findings that it is a proceeds of crime without any
Okay.
charge sheet, without anything else.
he has further submitted that it is erroneous on the part of the Learned Court to record a finding that the properties attached were acquired with the proceeds of the crime without there being any charge sheet till date. Issue notice returnable on 18/8 as Mr. Borua has appeared. The respondent state issuance of formal notice. The respondent state is dispensed to extra copy within 3 working days. The Learned Traditional Public Prosecutor shall obtain instruction in the matter every time. Post having regard to the provisions contained in section 107 BNSS and the facts projected in this petition, it is observed in the intent that the Court of Learned Judicial Magistrate First Class Morigam shall not proceed further under subsection 6 of 107 of the BNSS till the returnable date.
Obliged.
Item 4.
That is lordship. It's a revision petition. Lordship. It's against the order
dated 5/2/2025, as well as order dated
Yes, custody.
yes, Your Lordship. He is a registered owner of a vehicle, Eco Sports, which was,
First, tell me what is the case?
it's a NDPS case, Your Lordship. It's a small
NDPS case. Where is
he-
the FIR?
FIR at page Lordship 13.
Base
13.
13. Relevant part?
Relevant part, para 2, that is,
Base 13. Okay.
accordingly, we married
What is your name?
KK.
Dilnur. Dilnur Ali.
Dilnur Ali also.
We reached a particular place, found the car at the backside of a small shop in front of Law University. Gordon area. Okay, you were there inside the vehicle.
Yes, Lordship.
Okay,
There is 3 occupants. I am the owner. And
you were the owner.
yes, Lordship. And 3 grams of brown sugar is recovered as per the FIR. Which is a
25 with container.
Yes, I think without container, it is 3 grams.
Without. And suspected narcotics. Okay, then what happened?
Then we are forwarded before the Honorable CGM, Kamrup, and we are on.
That was on 14-3.
Yes, on the same date, we are released on bail, as it is involved in a small quantity.
Personal consumption. The offense is 21A.
21A as well as 29.
Accused person. And then,
we apply for the Zimma of the vehicle.
where is
It's
that order?
It's order annexer 5. This is the first order.
Annex of 5 page.
Page also 27.
Yes.
There is no wrong in the order, my lord. It is connection, but there is no wrong in the order, my lord, because checking from the vehicle.
No wrong.
No wrong, no wrong, no irregularity.
No infirmity.
My lord. And the owner, my lord, he was found inside the vehicle, along with the contract, my lord. And this figure, my lord, I rely on the, my lord, because there was a state of Assam, my lord. Very, my lord, the full condition, my lord. As to, my lord, if the owner, my lord, he will full, my lord. Not to make this, my lord. As to monitor, my lord, the owner is not allowed. Second to monitor, my lord, owner is allowed, my lord. If the vehicle is, my lord, stolen, or my lord, vehicle is, my lord, contaminated, recovered from the, my lord, passenger. Then only, my lord, owner can claim the car.
Get the instruction whether inventory has been prepared or not. Now, what is the procedure of 52A? Conveyance also in the inventory. Now, what is the provision for nowadays seizure?
As soon as, my lord, it is recovered, my lord.
Because we are into BNSS, not in CRPC. Biswajit Day is with CRPC.
Yes, yes, my lord. But, my lord,
451.
this will be the date.
Is it not? 451, 457, read with all the provisions of NDPS. Is it not? Now let us see the provisions of seizure in BNSS. So,
My lord, see, this is the case of an NDPS, my lord.
okay. What does NDPS says?
It can be
For
confiscated.
seizure,
Figure
which provisions are applicable?
52A, my lord.
52A.
My lord.
No, 52A is for inventory,
Inventory.
certification, drawal of samples. Inventory includes conveyance perhaps, NDPS.
And confiscation can be
Now,
done after.
what are the provisions of seizure here? Okay, Mr. Burua, in the NDPS, what is the provision of seizure? Come to page 51. Oh, sorry, section 51. Read.
It was a person arrested in Article 3.
No. 51.
provision of the Code of Criminal Procedure 1973 to apply to warrants, arrests, search and seizure. The provision of the Code of Criminal Procedure 1973 shall apply insofar as they are not connected with the provision of this act. All warrants issued and arrests, search and seizure.
Made under this act.
That is right.
Now we are in 2025. This case is of 2025. BNSS has taken over. Now let us see the seizure. Yes, Mr. Counsel.
Seizure is not prepared lawsuit, as per my knowledge. We have not, we cannot collect the seizure list.
What is the provisions for seizure?
Seizure,
In BNSS.
it can be seized.
Okay, you wait.
But my submission is that,
Your submission I will hear. Mr. Borua has made submission on the basis of Biswajit Day.
yes, sir.
Have you read Biswajit Day?
But your Honor, Sundar Bhai Ambalal Desai,
No, Sundar Bhai is for general.
yes, sir.
Biswajit Day
It is particular.
particular. BNSS or whatever, NDPS. And there are 4 situations are contemplated.
As I am the owner, Biswajit, they will come.
Biswajit Day says no. I am trying to find out whether you can make out a case or not. Yes, Mr. Borua, you have been handling BNSS. I have not been handling BNSS. Where is the provision procedure?
451, I think.
451 is release, sir. Release. 451. Let us see 451. Not 451. There will be different thing. That is in CRBC.
497.
497.
7 is the. Yes. 451 now 497 1 3.
497. Where is the provision procedure? Earlier CRBC seizure?
Oh, it's under the new BNSS.
In the CRPC, what is the provision procedure? Search and seizure.
Search.
105 or what?
105.
Six. One zero five C. One zero five. BNSS.
Recording of search and seizure to video electronic. One zero six will come.
Yes, this, I think. Then what happened? This is the order.
Yes,
Thereafter, anything more?
subsequently, we have filed again an application which was rejected. It is Annexure 6.
Yes,
At the best part of it, call for a report.
you call for a report whether when the seizure, because nowadays seizure is to be done audio visually recorded. And it is to be prepared. Everything is to be prepared. Somewhere I have read the provision that it is, if it is the seizure can be, photographs are to be taken.
In the PS,
Huh?
There is a provision in the NTPS Act.
Where is that? Because 52A2 says about conveyances.
42 madam.
42. Enter into A, B, C, such drive, substance, all materials. Huh?
The public.
Whatever you see 52A, subsection 2. Where so and so, so and so, so and so. Conveyances. You'll find conveyances containing such details relating to their description, quality, quantity, mode of payment, so and so, so and so. Such other identifying particulars of the conveyances
Where madam, videography is not.
may consider relevant to the identity of the conveyances in any proceeding and make an application to any magistrate for the purpose of certifying the correct inventory. And subsection 4 says that inventory certified will be a primary evidence. And now BNSS says, BNSS also says audio, visually it should be recorded. Right? Now question is about interpretation of Vishwajit Dikh. Whether, yes, ultimately at the end of the trial, it will be confiscated. It may be confiscated, but it is a case of interim custody. Okay, there are many other cases. We fix all the NDPS cases together. Tell me a date. You place the inventory. Copies. Investigation may go on. You get a copy of the. Okay. Heard Mr. K.K. Dekkal, Learning Counsel for the petitioner, and Mr. R.J. Borua, Learning Additional Public Prosecutor for the responding state post of the petitioner has referred an extended petition being agreed by rejection of his petition before the Learned Special Court or Learned before the Court of Chief Judicial Magistrate, Kamrup, Aminggaon. Not rejection of his applications by the Court of Chief Judicial Magistrate, Kamrup, Aminggaon. regarding custody of a vehicle bearing registration number AS-01 stroke FP-1592 by orders dated 5/4/2025 and 24/4/2025. Post of. It is the contention of the petitioner that the petitioner is the registered owner of the vehicle and the same was seized in connection with North Guwahati Police Station case number 30/2025. Within bracket DR case number 29K/2025. Close stop. On the other hand, comma. Mr. Burwal and a traditional public prosecutor has submitted that a contraband weighing how much?
3 grams.
3 grams was seized from inside the concerned vehicle. And when the petitioner and 2 others were occupants, right? Matter would require further consideration, issue notice returnable. 6A. Mr. Borua, so has submitted that he will produce the consent case diary on the returnable date. Yes, or no?
Kindly matter may be passed over after something.
Pass over.
May I please, Your Lordship? Your Lordship, the matter relates to criminal revision, Your Lordship, for the custody of the vehicle, Your Lordship.
Custody of the vehicle,
Yes, Your Lordship. Your Lordship,
NDPS.
NDPS, Your Lordship.
Yes, where is this FIR?
Your Lordship, the case was instructed by DRI.
Okay, complaint.
Yes, Lordship. Complaint is at page 19, Your Lordship.
Mainland Tautang.
Now,
Yes, page
page 19, Your Lordship. Complaint.
19. Intelligent officer.
Lordship on.
Mahindra TUV.
Yes, sir.
That is a vehicle.
Yes, Your Lordship.
How you are connected?
Your Lordship,
You are the occupant.
no, Your Lordship, I am the owner of this vehicle. Your Lordship, this vehicle was rented to one Paumin Thang by pay, Your Lordship.
Rented. How by in the form of
Lordship,
how it is rented?
the Lordship, he was a neighbor of mine. So on bona fide belief, he has asked the vehicle for a 1 week course. On bona fide belief, I have handed over the vehicle to him as I knew him personally, Your Lordship. And I did not, and it was not in my knowledge that he was illegally.
Then you will meet an accused?
No, Your Lordship.
No. Yes, who is the respondent? Let us see the inventory.
Page 25. Relevant portion at page 26, Your Lordship.
Copy of registration certificate. Bidding number so and so. Recovered. Inventory was certified or seen only?
Your Lordship, it was
What is the complaint? Let us see.
page 19, Your Lordship. May I read, Your Lordship?
No, that part.
Your
I
Lordship,
need to see that part. Inventory part
inventory.
in a complaint. The drawn inventory believed to be so and so. Vehicle documents. Apple so and so. Here. Rest. Yes, who is for the respondent? Have you served?
Yes, Your Lordship.
To whom? Nobody, his name is mentioned.
It was duly served before filing.
No, it is not mentioned. Had it been served, then it would have been mentioned. Normally. Huh? Who had received it? Then let us have it on Friday. Then. Mr.
P.S. Vishwas.
Vishwas, learned counsel for the petition is present. Most of none has appeared for the respondents today on call. Post of. There is no reflection of the respondent's name in the call list. Post of, as the respondent is enforcement director. Enforcement or? Ah. Yes. Yes, that is what. Name of Directorate of Revenue Intelligence, DRI. Name of Mr. S.C. Kal.
Yes, sir.
Learned. Standing counsel.
Yes, sir.
For the Directorate of Revenue Intelligence be reflected in the respondent's right call list. You have got the copy, otherwise? Huh? Please find out. You say on Friday again that we have not received copy. You sub a copy.
Yes, Lordship.
As an abandoned question, Mr. Vishwas, learned counsel for the petition, shall have a copy of the petition to Mr. Kal during the course of the day. Place the case on Friday.
Deeply observed.
Item 8.
Section 528, Lordship, for quashing of the FIR charge.
Quashing. FIR, charge sheet quashing, okay?
Consequence and PRC case.
What is the offense?
Open Lordship under 376.
Only.
376 filed by the daughter against her father and husband.
Volvo has appeared in second notice on behalf of the respondent.
Interim
Submission support.
Interim period.
You make submission. With this kind of document, shall I be able to reach an opinion that you have made out a privacy case? You should have waited for 207 stage to obtain the statements of the witnesses. Thereafter would have come. You have jumped the gun. The petitioner shall take steps for submission notice upon the respondent number 2 by extra AD as well as by usual process within 3 working days.
Item 10.
My lord, in this case, we are acting by an order, my lord. That is, at page number 58, my lord.
Page number
58, my lord.
80?
58.
Yes.
By this order, my lord, our prayer for recalling the witness, my lord, the PW1, who is the complainant in the NIA case, was rejected, my lord. Our case is that, my lord, the complainant filed 4 NIA case against me, my lord. And all those cases are in the same court, pending in the court of Additional Chief Judicial Magistrate, Shipsagar. So
You are the accused.
I'm the accused. So
Accused in all 4 cases.
all 4 cases. And the
Same complainant, same accused.
Same complainant.
Yes.
Same complainant. My lord, our case is that, my lord, I was forcefully made to sign a agreement. So, by making me sign the agreement, I was asked to hand over certain amount of checks to the complainant. Although I had no liability, but they made me accept liability. So
You are the signatory of the checks.
I'm the signatory also. So now I have challenged the agreements, the agreement by which I was made to
admit my liability. Actually, the case of the complaint is that I am his tenant from the year two thousand
So
seven.
let us see the order first. This Ramaya Engineering Service Limited. Ramaya Koda Sudhakar Rao. Konrakanto Bhai. Yes. Let us see
Page,
the order.
page, no, 11.
How many witnesses were examined by the complainant?
Two witnesses in this.
Two
case.
witnesses.
In this case.
Then any defense witness?
No, different. It is fixed for SD now on 8/8. Next date is on 8/8/2025.
I'm absolutely in agreement with this order. No further.
No, I'm submitting. Madam, may kindly see annexure 1, relevant portion, madam. I will see, this is the complaint petition filed against me, madam. Why
Now, what is the question of recross examination?
I'm just, para number 4, madam. Para number 4, I will take your motion.
When did you receive this copy of the complaint petition?
Complaint petition, I think I appeared in the year 2020.
You started appearing after receipt of the complaint petition.
Yes,
You were all aware about the averments made in the complaint petition,
yes.
right? Thereafter, complainant entered into the witness box.
No.
You had all the opportunity to cross-examine.
No, that is a different one, but the written statement was filed after the cross-examination. Written statement.
Then DW stage is available of you.
No, written statement. Madam,
DW stage is available of you.
No. Kindly appreciate, madam, page number 18, madam. My lord, para number 4. My lord, here the accused company through its director has a on the monthly rent of 1,04,000 from 2018 onwards, and thereby established a payment. Their case is that I am their tenant from the year 2018 onwards. So, but my lord, during
We are not here for reappreciate evidence.
no,
You have an opportunity
No.
to adduce definitively, you adduce definitively.
No, my lord, here it is a case, no,
No, absolutely not.
only one thing.
No, this is filling up the lacuna,
No,
absolutely.
not just filling up. They have filed written statement letter. We have, my lord,
I will impose cost.
My lord, cross examination, my lord, see, my lord.
No, absolutely not. Hard, Mr. Aichur. This is absolutely abuse of the process.
Cross examination.
Where is the recross examination or 311?
311, my lord.
No case is made out under 311.
Well-
Re-examination, then only recross examination. That provision is not there. Complaint has not
No,
entered into the witness box for re-examination.
No,
So there cannot be any recross examination.
no, we said.
And 311, you have not made a new.
Further cross examination.
Where is the further cross examination? No,
Further cross-
after closure, where is the provision for further cross examination? Show me from the evidence act. I cannot introduce new concept. Let us see evidence act.
Evidence, 311 CFS.
The first, let us see. Where is the provision for recross examination?
No, where 300.
Let us see first. Let us see. Is there anything new in the? What is this?
311 service.
137. Examination in chief. Cross examination. Recross examination. 138. Order of examination. Witnesses shall be first examined in chief. The cross. Then, if the adverse party so desires, cross-examine. Then, if the party willing, calling him so desires, re-examine. The examination and cross-examination must relate to the relevant facts, but the cross-examination need not be confined to the facts to which the witness testified on his examination. Direction of re-examination. The re-examination shall be directed to the explanation of matters referred to in cross-examination. And if new matter is, by permission of the court, introduced in re-examination, the adverse party may further cross-examine upon the matter. When there is no re-examination, no further cross-examination. This concept is out. Now 311.
311. 311 service. Page number 9.
Yes. Any court may at any stage of any inquiry, trial or other proceedings under this code, summon any person as a witness or examine any person in attendance, though not someone as a witness, or recall or re-examine any person already examined. It is the discretion of the court if for the just decision of the case.
No.
And court has said
No,
you have every opportunity.
Only a matter on.
No.
One
It is
question.
wasted of time.
No, only one question was put, my lord. Do you know about are you aware about the title suit that is pending against you? He said no. He said no. And
Good enough.
No. After that, my lord, after a few days, he appeared in the, my lord, the title suit, my lord. Title suit which he filed. And my lord, one more thing was that, my lord, we said that during 2018, I had no liability.
He said no. Then what section 157 of the Evidence Act said?
No, actually.
That itself is an impeachment of the credibility.
No, he admitted that he had accepted money from Surya Wires. I am saying that I was the employee of the Surya Wires.
You enter into the witness box yourself. Demolish his all credibility. You are in fear of being cross-examined, right?
No, I'm not. I have to give
Then-
my love. Because
Why you are this tactic? To fill up the lacuna?
not fill up the link, my lord. But he has stated something wrong.
The instant female petition. Under section 4, for 528 of the Bharatiya Nagaric Code of Ahomita has been instituted to assail an order dated 25/6/2025, passed by the Court of Learned Additional Civil Judicial Magistrates, Hibohagar, in NI case number 10 of 2022, by the order dated 25/6/2025, comma, the trial court dismissed a petition, comma, petition number 5. Sorry. This is a petition filed by the petitioner who are facing petitions, who are facing the trial as accused, comma, 2, further cross-examine the complaint that the complaint of NIA case number 9 of 2022 has been instituted by the complainant, who has been carried as the sole respondent in the instant criminal petition, comma, with the allegation that number of checks issued by the petitioners in his paper from an account maintained by the petitioners stood dishonored when dishonored on the ground of insufficiency of fine, when the checks were presented for collection. Most of the complaint as well as that the petitioners have committed an offense under section 138 Negotiable Instrument Act and the Learned Trial Court on institution of the complaint to cognizance of the offense and issued process against the accused persons, that is the petitioners, who upon receipt of process entered appearance in the case and thereafter are contesting in the trial. From the materials on record, it has emerged that the recording of evidence of the complaint side has been over, and on 25/6/2025, the case was posted for statement and defense. First of, it was prior to 25/6/2025, the petitioners preferred a petition, petition number 5178 2025. Under section 311, CRPC, with a prayer to allow the accused side to further cross-examine the complainant. Post of para. It is relevant, pertinent to mention that the examination and cross-examination of the complainant was concluded on 17/8/2020. Post of para. In order to appreciate the it is appropriate to relevant. It is appropriate to extract the relevant parts, relevant excerpts of the impugn. Page 89. Oh, you were also irregular also.
No, my lord, not irregular. My lord, I'm.
Imposed cost.
No, I have annexed them, my lord,
Anyway, we are not concerned with that.
No, my lord.
Anyway, we are not concerned with that. Conflict stands rejected up to 93. Mr. Chaudhary and House of Court of Petitions have submitted that the trial submitted that when the complainant was asked a question during cross-examination as regards pendency of a civil suit, the complainant answered in the negative. First of, yes, Mr. Chaudhary has submitted that it on the date of giving such answer, there was a civil suit instituted by the complainant himself.
No, not complaint, by the.
By the petitioner's side as the plaintiffs. And the complainant had already received the notice in the said case. First of, in order to question the complainant on the said aspect, re-examination, re-cross-examination, further cross-examination of the complaint is necessary, and in that view of the matter, the petition under section 311 CRPC was filed. Also, para. As stated above, as mentioned above, the evidence, examination in chief, the stage of examination in chief and cross-examination of the complainant was over on 14/8/2020. Post of section 137. Has provided for only examination in chief, cross-examination and re-examination. First of section 138 of the Evidence Act has provided for the order of examination. First of, as per section 138, once it section 138 also has provided for direction of re-examination. Absolutely. Re-examination will be directed. First of, para. There is no provision for further cross-examination of a prosecution with witness unless the prosecution side itself calls the witness for re-examination. Question. Para. The provisions of section 311 has inter alia provided, has empowered the court to recall and re-examination any person already examined. And the court shall summon and examine or shall recall and re-examine any such person if his evidence appears to the court to be essential to the just decision of the case. The reasons assigned by the learned trial court for not allowing the petition of the petitions are found to be well informed. The accused side had all the opportunity to cross-examine the complainant. After closure of the evidence of the complainant, another witness was examined and cross-examined. If the impeaching the credibility of the witness like the complaint is the object of the petitioners, the same can very well, such object can very well be achieved by the petitioners by entering into the witness box as the case, NI case number 10/2022 is at the stage of defense evidence. Full stop. The petition filed under section 311 CFSC. The considered view of the in the considered view of the court is an effort to fill in the lacuna left, apparently left by the accused at the stage of examination, and such filling of lacuna by way of further cross-examination is not permissible. In the above view of the matter, there is no, this court finds no infirmity in the order dated 25/6/2025 passed by the learned trial court, as the said order is found to be well written. Consequently, this criminal petition is bereft of any merits, and the same is accordingly dismissed.
I can explain so many. I can explain. Only case number
Item
15, 1.
1(8). Case number is different.
NI case number is different.
Order,
Order is same. Order number date is same. Order date is same.
reasoning,
Same.
reasoning is same. Silo. You go and reduce defense evidence, you have all the opportunity to drag the matter you want. Not by this. If people are allowed to approach this court at the drop of a hat, it will be difficult. Dismissed. It is allowed.
Here we are challenging the criminal proceedings initiated against the petitioner under NI Act. In fact, there have been 3 checks plots and 3 different proceedings. But we have filed 3 criminal petitions plots. In fact,
3 different proceedings, 1 petition.
No. For 3 checks, 3 different proceedings. In 2 of
Okay.
the cases plots, I am having interim protection by your office. The background is this.
In criminal petition.
Yes, Minister, if I can.
What is the ground of challenge?
No, the challenge is not the
What is the
petitioner.
complaint petition?
Yes, page. Page 27, Lord.
Page 27.
Yes.
Okay, you are an accused.
Yes, if your lordship come to page 28, accused number 2.
Presently working as director.
Yes.
DIN,
Lord,
you are a director.
No, I am not.
It is a registered company.
Yes, I am not a director.
Where is that?
Lord, kindly come to page 45.
45. Okay, 2 other persons.
Yes, and for 46, the subsequent
On
director.
the date of filing the complaint,
Lord, I am none of this. Lord, the date is 46, page 46, your lordship.
it was instituted in December. Okay. This is of February. So you are not director.
I am not a director. Lord, I am.
No, not a signatory.
No.
Who is the signatory?
Signatory is the other director, Lord.
Authorized signatory. That
Yes.
one.
Vikas Das. Yes.
Okay.
Lord, I am a government employee, Lord. I am
Government employee.
Yes. If your lordship kindly have a look at page 41, Lord, for a moment.
41.
Sorry, but
District Deputy Registrar of Cooperative Societies.
yes. Lord, I had to disclose my annual property, which I had done at page 42, if your lordship sees. At serial number 4, Lord, I am the owner of shareholder, 100 share.
Okay.
So I am a shareholder of this company. And Lord, directors who were aged, Lord, they wanted to change the management, give it over to the complainant. And I was authorized only as a signatory at page 48, if your lordship sees. Second parameter, whereas the director of the first party due to their age and occupancy are unable to manage this tea garden and therefore as such approach the second party lessee to manage. Whereas the directors and shareholders of the first party has authorized Srimati Navanita Pathak, who is one of the shareholder, to sign this. Now, because I have signed, now the dispute has also cropped in between the parties. No, that we.
Is there any amendment that in charge
No.
in the complaint?
What?
Day-to-day affairs?
No.
No.
Because they only say that it has been done at my instigation. But in a case under 138, I cannot be proceeded with until unless
That 141,
Yes.
section 141,
subsection 4.
amendments
Yes.
are made in the complaint.
No, my lord.
No.
No.
That is also not made. Are you clear?
They only because of that, what has happened, they say me that I am a
What is
director.
that amendment required to be made otherwise?
My lord, if you
141.
sees this entire
No,
thing-
can I? Hard, Mr. Yes. Where is that? This is no reason. The order is of no reason.
My lord,
The order,
yes, no, that's why I am facing the facts. Show your lordship's plans. No, in fact, entire facts was placed.
हाँ, 141, offense by company.
Yes. So their entire case is I am a director, and being a director,
I heard Mr. Dubey and counsel for the petitioner. Ms. Bora, you are pretty here,
formal party member.
Okay. And Ms. S.H. Bora, learn an additional public prosecutor for the responding number 1, state of 2, state was some. Full stop. The respondent number 1, as the complainant has instituted a complaint, complaint case number 3935/2024 before the court of learned Chief Judicial Magistrate Kamrup Metro at Guwahati, Green Bracket Trial Court. Alleging commission of offense under section 138, read with section 142 of the Negotiable Instrument Act, arraying page 1, page 28, 1 to 3, to the bracket the petition as the accused. Post para and a learned trial court.
Page 37 is the order.
On 10/12/2024 to cognizance of the offense under section 138 of the Act and issued process against the accused persons arrayed therein, including the petitioner. The petitioner has preferred the instant criminal petition under section 528. BNSS seeking passing of the criminal proceedings of complaint case number so and so, insofar as the petitioner is concerned. The main grounds of challenge are entirely that the petitioner was not the signatory of the check which was dishonored, and the petitioner was not a director of the accused number 1 company on whose behalf the dishonored check was issued by the accused number 3 as the authorized signatory. As per it is Mr. Dubey as referred to the what does it call, page 45?
Page 45 is the lease agreement, bro.
No, page 45.
Page 5 blood is the extract from the Ministry
Extract
of Corporate Affairs.
obtained from the Ministry of Corporate Affairs, Government of India.
Called master data, part of the
Master data of the pertaining to the accused number 1 company available in the Ministry of Corporate Affairs, available with the Ministry of Corporate Affairs, Government of India. So as per the master data, 2 other persons are the directors of the accused number 1 company. Moreover, it is contended that the petitioner is only a shareholder of 100 shares of the accused number one company. Let it was that the petitioner being a government servant serving in the Corporation Department, Government of Assam, is not not a full-time, is not a director of the accused number one company. Posto. Further, come on, there is no averment in the complaint petition which meet the requirement of section 141 of the Negotiable Instrument Act. Issue notice returnable within 4 weeks. The petitioner shall take steps for service of notice upon the respondent number 1, 3 and 4 by registered courts with AD within 3 working days from today. I will let you know as Miss for as a peer accepting notice or 2. Having regard to the position made on behalf of the petition in the apostolic manner, the further proceedings of complaint is so and so number. Presently pending in the court of judicial magistrate or judicial magistrate.
Judicial magistrate first class now.
Judicial magistrate first class. Hibohal. Sorry, Kamrup Metro, Guwahati. Shall remain state insofar as the petition is concerned. Till the return.
Therefore, taking this case along with other criminal.
Let me, it has been issued 4 weeks, so thereafter you take months.
13.
Well, this is a case for pushing of the proceedings related to Bayhata Charlie PS case 8325. The FIR is in page 9.
PS9.
Now, may I read? I would like to beg to you that I, Sri Anantadev Saikia, father, late Yogin Saikia, complained residing in Guwahati by occupation. I have a plot of land in my name measuring 3 Kotha 9 Lesa Khiraj Miadi, land dark number 291, Patna 143, Dakshin Lenga Gaon, under North Guwahati Revenue Circle, Moja Borbongsor. Land is enclosed and occupied by the title of the land by accused number 1, who is the.
Is it a translated copy?
Yes.
Let us understand from the vernacular.
Page 15 is the original.
Yes.
Now take you to page number 19.
You are Sunita Son.
I am Sunita Son.
Okay.
The informant has filed.
Okay. Naam and Dokalat. Okay.
He has produced the declaration, notarized one. He has stated that I have filed the FIR dated 1/4/25 lodged before Bayhata Police Station 8325 out of misconception of facts and misapprehension. And now I do not intend to proceed with the above mentioned case.
Case was registered under what section?
Is registered under.
Basically cheating, forgery or what?
Yes, Your.
Let the lady come, oh sorry, let that informant come.
Your Honor, a short date may be given. I may be allowed to take custody. And in the meantime, a stay of the proceedings may be allowed.
You got bail or what?
No, I have not taken any bail.
Huh?
I have not taken bail.
Investigation is still going on.
No, still. Let the lady come.
No,
We'll quash it.
yes, sir. No, stay of proceedings.
No, stay of proceeding.
When I'm ready to take custody also.
Okay, you take the stay also. Hard, Mr.
G. Kaushik.
G. Kaushik, and counsel for the petition, and Miss S. H. Boral, and additional public prosecutor for the respondent. number one, comma, state of some postal para. The instant criminal petition under section 528 BNSS is preferred seeking passing of an FIR. First information report lodged by the respondent number two as informant. Post of the same FIR has been registered as Vaihara Sarili Police Station, case number 83 of 2025, under sections. Para. In the FIR, comma, the respondent number two as the informant has alleged that he has entirely alleged that he is an owner of a plot of land, comma, described therein, and it is the accused number one, comma, named in the FIR, comma, that is the petition, who took the said plot of land under her possession and got the mutation and got her name muted in respect of said land. Post of para Mr. So-and-so land council board of petition has submitted that subsequently, comma, the informant that says respondent number two has executed, has sworn an affidavit, comma, annexed as an excerpt Roman 3 to this petition, comma, stating that he lost the affair out on misconception of facts and he does not want to proceed with the case. Post of para. You should notice returnable short letter given. What it will be given. As Ms. Bora has appeared accepted notice on behalf of the respondent number one. Extra copy. The petitioners will take steps for submission notice. The respondent number two by registered post JD as well as by individual process within 2 working days from today. Post of in addition, comma, as sought for, comma, the petition is permitted to take steps for submission notice upon the respondent number two by way of trustee, which is to be taken through the so compliance evidence.
Okay. Item number 14. What is the present petition is against the order of warrant. The petitioner has been issued non-available warrant and proclamation on the attachment. So writing part of the order is page 17. On 6/4/2020.
What is the charge sheet?
Charge
Charge sheet.
is not
FIR.
annexed. The FIR is annexed and charge was framed.
Charge was framed.
Yes, page 15 lots. Under section 21B and 29 of NDPS.
You are
I'm the accused person.
Iraq Judy now.
Iraq. Nah.
Okay, against you charge has been framed.
Yes.
When? On 24th of March 2022.
22.
Yes.
They are,
Meaning thereby you started facing the trial.
yes,
Then what happened?
thereafter on 6/4/2024, the petitioner was not present before the court and accordingly NBW is issued against him.
Oh.
Subsequently, on 24/1/2025, PNA is issued. Annexure 4, page 25.
So what happened from 6/4/2024? All this while you were absent,
Yes, NBW is issued.
right?
Thereafter, the petitioner could not appear.
For what reason? Whole machinery you have kept waiting. Huh?
He was in a rehab.
Special judge is appointed to conduct the trial and he has been,
Now petitioner is wants to appear before the trial.
it is not as per your whims and caprice. What is your reason?
He was in a rehabilitation center. I have stated in case para 6 also. My opinion.
Rehabilitation center. What is para 6? Sir, what kind of document is this page 28?
Yes, okay, it was.
A better document, otherwise it is very.
Yeah, it's the rehabilitation center, but it was the superintendent, so he provided.
Yes, Mr. This can be,
Possible time, the charges were framed on,
if we were good at graphic designing or whatever, you can take out a document like this.
this is framed on that we parts there. The order that has been annexed to the 24, in between, that is here.
He started not appearing
From 22,
6/4/2024. It looks like,
yes, but
right?
from 20.
Okay, 6/4/2024. Now paragraph 6, he has said he was in rehabilitation, right? But page 28, have you seen page 28?
Plus.
It does not inspire confidence.
Petition.
Anybody can take out such kind of document. No signature, nothing. At least you should give some handle to the court. Otherwise, there is no challenge as regards the legality and validity of the order passed. Court has rightly passed the order.
I think extra 4 million. Very good PNA will say.
DNA is not complete. The process is not yet complete.
Again.
Not yet complete. I have seen it. Right? The process has been initiated.
Thanks, it is.
Yes, but still it is not complete because enquiry officer has to be examined thereafter. But so far, you should have come with better documents, sir. Page 28. Something should be there. If you have really undergone rehabilitation, I can understand that it may so happen. Anybody can take out. Thank you, congratulations. What is this?
I'm be a lot of time. I will highlight that.
Come with better document. At least there's certificate to that effect. Otherwise, sir, an order rightly passed cannot be interfered with. All these orders are rightly passed.
Sometime maybe.
There is no ground to set aside those orders. Somehow on humanitarian ground, we can kept it under suspension to allow it to appear to facilitate an expeditious trial. But so far, this congratulation document will be very difficult for us to digest. You come up again. We close this. If I get a better document, if it is a rehabilitation, definitely we will allow. But come up with this, not congratulation, thank you. Right? 1 lakh copies can be made of this document. Do you withdraw? Or dismiss? I'll dismiss.
I may be allowed.
Mr. T. Shutian, current counsel for the application, has submitted that the petition may be allowed to withdraw this petition in order to file afresh with better particulars. So Mr. Goswami, MP Goswami, Larachi. Additional public prosecutor has submitted that the state has no objection if the prayer is allowed. Also, in view of the above submission made by Mr. Chukiel and court of petition, petition is dismissed on 12 with the liberty as paid for.
Item 16.
Petitioner before your lordship is an officer of APDCL. He has challenged the proceeding, lordship. The lordship will find the FIR at page 19. The allegation is that lordship, because due to electrocution, 2 wild elephants died.
Chief Minister, so I have the honor to inform you.
2 wild
That-
elephants died, lordship, because of electrocution. And the petitioner,
Pedipent.
yes, lordship.
Badly.
And a petitioner who was serving as a junior manager at that particular point of time, including a lineman, they were charged under 429 IPC and 51 and 58 of wildlife protection.
429 IPC, what is that?
It is
429 IPC?
Causing mischief to animals, lordship, listed animals.
Oh, mischief.
Yes.
Yes. There is search it,
Lordship. The charge sheet that lordship,
search it. Yes.
may I kindly take your lordship to page number 24 of the charge sheet. It's a translated copy. The reason being that why the petitioner is charge sheeted and charged under the offense is that they did not inform the then SD
This is completely dereliction of duty.
lordship, but your lordship.
Clear case. On
Yes,
the other hand,
your lordship will fancy.
and what is this other offenses, forest offenses?
Forest offensive. Your lordship may kindly see page number 24 for a moment.
Yes.
May I read lordship? The relevant part on the other hand, the lordship is found. There are number 1, 2, 3, 4, 5, 6, 7, 8, 9. On the other hand, the in charge of electricity department, ST Miss so and so, during investigation stated that she was not aware of the area as she had taken over the charge of the electricity department only a few days back, and regarding the lines running in the area, it was informed that the lineman and the junior manager did not inform her. Now the charge sheet nowhere says that the junior manager, the petitioner being the junior manager, was in the capacity of the SDE or he was taking the charge at that particular point of time. Only the person who was having the charge at that particular point of time could have been charged under the offenses as claimed by the prosecution, lordship. If at all there is a case. If there is a case, only the person who was charging the electricity department at that particular point of time.
You are saying that you were not there.
He was there, but he was not the.
Tell me, you were not there, okay.
Lordship.
At the relevant point of time.
He was there, lordship.
He was there then.
Yes. But he was not heading the department at that particular point of time of that.
Whether he should be the head or he should be the head of, in charge of the line.
In fact, charge sheet nowhere says, lordship. Charge sheet nowhere says that he was in charge of.
Then cognizance is taken or not?
Yes, the cognizance order is also lordship. It's a mechanical order. Your lordship will find
it's
that.
required to be well reasoned.
Not even well reasoned.
Cognizance.
There is not even a reason, lordship. At page 31, your lordship will.
Show me what is the law regarding the cognizance order.
Lordship, this is a recent judgment of the apex court, which says that there has to be at least some whisper.
Whisper, privacy case.
Yes, that is what Supreme Court says in JM laboratories and others. It says that it is not, it will be not sufficient.
This cognizance on, there are many authorities.
Yes, lordship.
This goes that way, that way.
Yes.
Now, did you make any petition for recharge?
No, lordship.
To avail that opportunity, then it will be easier for us to decide. This is a sessions tribal or?
Sessions tribal because
Sessions
of the
tribal.
order protection.
So, a high-ranking judicial officer will be in charge.
Lordship.
Approach under 227. Otherwise, it will be very difficult for us.
Otherwise also it will be difficult.
You appear before him under 227, file an application for discharge.
Otherwise also it will be difficult for me, Lordship, because the charge sheet says based on the statement of the witnesses, the charge sheet is.
Right, but still,
That
if those statements
Yes.
are presumed to be true,
Good.
and even then, no case under these sections are made out, then you are liable to be discharged. And
29
then we can have the reasons.
Yes.
Then we can exercise our discretion. Here it is very difficult.
429 is not affected, but in respect of.
Wildlife letters?
Yes, wildlife may come.
I think you better 227 you appear. Now it is what I don't know BNSS. Similar provisions are there or not? Because then we'll have the records
Lordship.
and the reasoning. Obtaining discharge. Discharge is there.
Yes.
The accused may prepare an application for discharge. Section 250 now. If upon consideration the record of the case and a document submitted therewith after hearing so and so, that there is an opportunity of hearing, not sufficient ground, recent discharge, then that order is revisable and we'll have the reasoning.
Yes.
Otherwise, we are
I got your Lordship. In that case, your Lordship may kindly grant the liberty. Your Lordship may not dismiss this petition.
no. When it was 11-5,
Lordship.
case is put up along with the case diary. Reduced, case is transferred to the. No, it is JMFC.
JMFC have taken the cognizance. Now it is committed to the Court of Session Judge.
No. Come to page 31. CGM. He sent it to JMFC.
JMFC. And then JMFC committed it to the Court of Session Judge. That your
Court
Lordship
of
will find
Session
at
Judge.
32. Page 32 and 33.
That is 20/05/2025. Right?
29/01/2020.
The date of
Committed
fixed
to-
for
Yes,
appearance
appearance.
before the Court of Session was 20/02/2025.
Yes.
So what happened thereafter?
He
Any
already
idea?
appeared and copies have already been furnished. to him.
Copies are furnished.
Yes.
Then charge has been framed.
No, charge is yet to be framed.
Or charge is yet to be framed, then he make an application for discharge.
But
Will not-
kindly make an observation. that-
Will not observe because there is a period of limitation also.
That's it.
If it is dismissed, then you come.
That's it.
I think 60 days. 250, Mr. Sharma said.
250 सब कर
60 days have gone, right?
Yes.
From the date of commitment of the case.
29. I can come under 528 also. If there is an issue of complaint.
But still subsection 2 is available. Because argument can be made without any discharge application. For discharge. Before framing the charge, these requirements are to be fulfilled.
Yes.
But Mr. R. Bora,
That's it.
then a counsel for the petition, and Mr. B. Sharma,
special
then it's special public prosecutor
one minute.
for the respondent number 2. Okay, S.H. Bora, then additional public prosecutor for the respondent number 1, huh? Post. The petitioner is presently serving as the range officer.
Now he is the SD.
Oh, sorry, APDCL, right? Is presently serving as junior manager within bracket electrical.
Electrical merchant.
And is an employee of Assam Power Distribution Company Limited, APDCL from Assam. Full stop. The response number 2 lodged an FIR report. The officer in charge, Keroni Police Station, stating injury letter on 16/12/2020. 2 wild elephants died due to electrocution caused from electric wires at Bogori Ghat paddy fields. The FIR has been registered as Keroni Police Station, case number 187/2020. Under section 429, Indian Penal Code, read with section 51 within bracket 1/58 of the Wildlife within bracket Protection bracket close Act 1972 against the petitioner and another employee of APDCL on the ground that the incident happened within their jurisdictional areas. After investigation, a charge sheet being charge sheet number 125/2020 came to be late seeking trial of the 2 charge-sheeted accused persons therein, which includes the petition. The Court of Learned Chief Judicial Magistrate, West Karbi Anglong Hamrin, on 11, what is the date? This is 31?
11/5/2023.
23. Finding a veracity case took cognizance of the offenses after accepting the charges, and the case was transferred to the Court of Learned Judicial Magistrate First Class, West Karbi Anglong Hamrin for disposal on 29/1/2025. The Learned Judicial Magistrate First Class Hamrin, West Karbi Anglong, in the concerned case, PRC case number 97/2023, allowed the petitioner to go on PR bond till his appearance before the Court of Sessions. As the offense says under the Wildlife Protection Act 1972 are tribal exclusively by the Court of Sessions, the case records of PRC case number 97/2023 was forwarded to the Court of Sessions, West Karbi Anglong, with a further direction to the charge-sheeted accused persons to remain present on the next date of posting, 22/2025 before the Court of Sessions. Mr. Bora and counsel for the petitioner has submitted that the instant criminal petition under 528 has been referred, seeking crossing and setting aside of the order dated 11/5/2023 and the source dated source number 125/2020 dated 31/12/2020. Apart from the proceedings of PRC case number 97/2025, which have been registered 2023, which have been registered as sessions case number 04/2025. Close to. But after hearing the learned counsel for the parties, this court reserved the considered view that the petition has a remedy of seeking discharge under section 250, BNSS. Subsection 2 of section 250 BNSS has provided that if upon consideration of the record of the case and the documents submitted therewith, and after hearing the submissions of the accused and the prosecution that we have, the judge considers that there is not sufficient ground for proceeding against the accused, he shall discharge the accused and record his reasons for so doing. As the case record and any order passed on in the matter of discharge is an accused, if aggrieved by any order passed in the matter of discharge, has further remedy. As an order in a matter of discharge is to be decided recording regions upon consideration of the records of the case and the documents submitted therewith, this court is of the considered view that the petitioner should exhaust the remedy under section 250 BNSS at first before invoking the provisions of 528. What is the revision or provisions in this BNSS? That is 3997 and 401. What is it? Before invoke 528 BNSS and stroke 438, section 438 BNSS and stroke or section 442 BNSS. In view of the above, this criminal petition is closed, reserving the liberty to the petition to approach the jurisdictional court of sessions to invoke the provisions of section 250 BNSS. It is further observed that it remains open for the petitioner to seek recourse to appropriate remedy in the event the petition is aggrieved by any order passed under section 250 BNSS. Yes, Mr. Sharma, anything?
Item 17.
Sahid Ali, yes,
May I please law?
yes.
Here, my lord, the FIR plot is 12. The challenge the entire proceeding, my lord.
Entire proceeding of 528. Okay. Impugn order. What is the impugn order?
Impugn, my lord, taking cognizance, my lord, under section 399 against my lord single accused.
Impugn order two, subsequent order. NBWA, proclamation and attachment.
Subsequently.
Huh?
Lordship, first he appeared, then he was granted bail, my lord. Then charge sheet, my lord. After charge sheet. And
During investigation, you got bail.
Lordship,
Then charge is submitted.
submitted.
Then summons.
Then someone
Then
without someone NBW issued, then my lord, he appeared, NBW recalled, and he was allowed to remain on previous bail.
yes,
Again, my lord, NBW issued, because he was absent, my lord, in the proceeding.
absent. Now, what is the stage of proclamation?
My lord, as per report, it was not executed, my lord.
OC is directed to execute. Submit a report. 926.
And
Is
next
absent
date,
for
next date is,
return
my
with
lord,
reports in the report civil state with the so.
next date is, my lord, 30th of
Issue
August,
attachment.
is 43.
Attachment issue is not yet received, be issued.
Last order, my lord, is 43. Fixing, my lord,
17. Yes, Mr. What is the law?
So the CPA kindly see now, there was matter, first he was granted bail. Again, after such sheet matter, he again defaulted there because again he came, that matter, he had not received the sum. Then again he was allowed to go on previous. There, again he defaulted for so many of it. After getting the bail the second time.
Legality of the order, I don't think there is anything for him. He says ready and willing, perhaps.
That is one.
and other part, my lord, it will lordship consider, my lord, 399. Against single person, my lord, it will be not applicable.
That is a matter. We are
Because, my lord, Dokaiti, my lord, in case of Dokaiti, my lord, more than 5 or more person, my lord, is
How many have been charged?
only one.
Maybe the session, it is presently pending before whom?
My lord, before they landed, my lord, wasted,
It is to be committed or what?
it is to be committed if, my lord, 399.
So,
And if, my lord,
399, then
if, my lord,
thereafter, the provision is there. If that 399 session just finds them not attractive, minor offense, again send back. That provision is there.
that was,
But for that purpose, you have to appear.
I have to appear, my lord. So, my lord, NBW, that portion may be recalled, my lord. I will appear and.
We cannot recall. You appear.
I will appear, my lord.
Only keep it under suspension
Lordship.
till the particular date. Thereafter, the judicial magistrate, first class will take over on merits and in accordance with law. We'll keep it under suspension. That we can do. We cannot set aside any NBW. If somebody has set aside, I don't know. Petitioner. And Mr. MP Goswami, additional public prosecutor for the respondent state. Postal. The effects leading to the institution of the instant criminal petition under 528 PMSS can be stated, in brief, as follows, column. On the basis of an FIR lodged on 26/12/2017, a case, Tarabari Police Station, case number 346/2017, was registered for the offense under section 399, Indian Penal Code. Postal. During the course of investigation of the said case, the petitioner was arrested on 26/12/2017. And subsequently, the petitioner was released on bail on 14/3/2018. Postal. On completion of investigation, a charge sheet was submitted in connection with Tarabari Police Station case number 346/2017 on 31/3/2018 against the petitioner as the sole solicited accused person for having found sufficient materials for committing the offense under section 399 IPC. The on submission of charge sheet, the Court of Learned Judicial Magistrate First Class Borbeta took cognizance of the offense under section 399 IPC in PRC case number 338/2020, which arose out of Tarabari Police Station case number 346/2017, and issued process within a summons to the petition for his appearance to stand in the trial. Postal. The learned trial court had thereafter, issued non-bailable warrant of arrest against the petitioner on 26/3/2020. Postal. On 1/10/2022, the petition appeared before the learned trial court and made an application to recall the NBWA issued against him and to allow him to go on previous bail. The learned trial court by order dated 1/10/2022 was pleased to allow the petitioner to go on previous bail. Subsequently, due to default on the part of the petitioner to appear in the trial, the learned trial court issued bailable warrant of arrest at first and subsequently non-bailable warrant of arrest. Postal. By order dated 31/8/2024, the trial court issued NBWA and order for proclamation and attachments. Postal. The process of attachment, proclamation and attachment have not yet reached a final. Postal. The petitioner has submitted that the petitioner is ready and willing to participate in the trial, and because of the apprehension arising out of the currency of the NBWA issued against him, he has not appeared before the trial court till date. The petitioner also raised the contention that for an offense under section 399 IPC, more than one, how many? 5?
More than 5.
5.
5 and
At least 5 persons should have been chassis. As the trial before the court of learned judicial magistrate first class Borbeta. He is pending. Since when it was submitted, Sarsit,
Cognizance taken, on.
Considered on.
cognizance.
Cognizance, 3/2/2000.
3/2,
2/3/2020.
2/3/2020. SARS framed or not?
No, one, cognizance taken. SARS will frame by the learned session judgment. Because session trial will.
Why he was delaying? The court is also delaying. Huh? If it is,
For the appearance.
no, then he appeared also.
Once he appeared.
Only one occasion or
Only
what?
one occasion he appeared on the
Sa-
day he
up-
got bail, and again he.
2 years by trial court in taking cognizance.
Since when, so, this court is of a considered view that an ex-CS conclusion of the trial is called for. So as the petition is ready and willing to participate in the trial, this, the instant criminal petition, this court is of a considered view that the petitioner shall appear before the trial court on
Next date is 30, my lord.
30
Last
July
30
or
days, my
August.
lord. August, my lord.
Now you appear on 1st of August.
Within 10 days.
Within 10 days, 1/8/2000. On or before
or before.
1/8/2025. Posted. For securing ends of justice, it is provided that till 1/8/2025, the non-bailable warrant of arrest issued against the petitioner shall remain suspended.
As well as PNM.
PNA is different thing. PNA does not lead to your arrest. Poster. It is further observed that in the event the petitioner appears before the trial court and makes an application for his bail, the learned trial court shall consider the same on its own merits and in accordance with law. Poster. The above observations and directions from the instant petition is disposed. Yes, Mr. Bora. Let us see after the orders, admissions, or otherwise tomorrow we'll try. But that judgment, the Nariman judgment, Tufan, has not overruled that.
But Lordship, kindly see paragraph 128 and all. It has clearly stated, they have quoted this judgments.
Will she that?
Well, that is.
Not right now.
That further, but then paragraph 128.
He'll be called.
Well-
Let she be there.
Item number 19.
Please, your lordship, petitioners before you, on being agreed to the order dated 6/5/2024, passed by Judicial Magistrate First Class. And my lord, judgment and order dated
Page
18 to 24. This is the first order passed by Judicial Magistrate First Class, Noagao.
Judicial Magistrate First Class, page
Page 18 to 24.
18 to 24.
18 to 24.
18 to 24.
Sorry. Not that.
That is different.
No, 25/26. 25/26. Last part, my lord. Number one of the last paragraph. Instant case directed to pay a proceed amount rupees 1 lakh and other necessary medical expenses for the child.
Page?
Of page 26. Last paragraph. Thereafter, my lord, on being aggrieved with this order, under section 29 of the DB Act, appeal filed before the session judge Nagao. That is the judgmental order dated 24th of March 2025, page 27. The same order was upheld by the session judge.
What is the reason for 1 lakh?
A reason
for medical obligation?
for medical obligation, my lord, kindly, there is a problem in the child's,
Yes.
but the petitioner is ready to pay. But thing is that if he pay the money to the mother of the child, it will be misutilized.
Mother for the child will meet.
In
Mother
earlier,
who pays the medical expenses for the child.
but
Can you expect the mother not to treat the child? He has vision problem, ear problem.
no, he will attend with the child.
Okay, you first deposit the amount to the registry.
But
We'll
now
call,
without considering the financial status, my lord, and the case is pending. That is affidavit on assets
are you
and
not
liability.
concerned with your child? Who has a vision problem, ear problem?
Already I have given earlier in so many times.
So that is why I say you
That's why
deposit the amount to the registry. We'll decide about release or not to release.
Petitioner just want that whatever may be the amount required, he will pay. But
We'll
whenever
see
he
to
will
that.
he will attend with the child.
We'll see to that. Why, since you are ready and willing, you deposit the amount to in the registry. Will not release the amount to the wife. Let her appear. Yes or no?
Let her appear.
Or you deposit in the meantime. Show your bona fide. Show your bona fide.
At that time,
Show your concern for your child. Okay, since 6/4/2025, 4, page 25, order. What amount did you deposit?
25,000 minimum.
No.
Actually, my-
6/5/2025. What expenditure you have made for your child? What expenditure?
She claimed 1 lakh rupees.
No, I am not saying that. The child is with you. How old is he? How old is he? Your child? 5 years, 6 years.
5 years. 6 years.
6 years now. Now, since 6/5/2024, he has a vision problem. He has a hearing problem, right? Since 6/5/2024, what amount you have given
No amount.
to your, no,
No
then
amount.
you deposit. Show your bona fide. You have a responsibility to treat your child
Yes.
or no? Say no.
Both the parents would not only.
She is having the child, she is treating the child, she is taking care of the child as on date. What amount you have paid? Since 6/5/2024.
No amount.
No amount. Then show your bona fide. We are not releasing. You deposit the amount in the registry. Thereafter, let her appear. We'll find out what expenses she needs for taking care of the medical treatment of the child. Thereafter, we'll decide about the disbursement. Otherwise, you have no case. You have a responsibility to take care of your child.
Earlier, several times 50,000 paid.
Since 6/5/2020.
But since 6.
That is what I have asked. Last 1 year, more than 1 year, you have not paid anything. Despite an order, was there any order of stay? initially when you prepared the appeal? No. No, then you are disobeying order of the court. There was no stay. Let us see the judgment.
Page
We
27.
may not enter it
Page 27.
on merit. There is nothing. There is nothing. On what ground you have challenged?
In my lord,
On what ground?
paragraph 10, my lord. Page 6.
Will issue notice. In the meantime, you deposit the sum before the registry. Let us see the affidavit annexer 2.
Affidavit on assets
Hmm.
and liabilities.
Page,
Page 19.
page 19.
Start from 18. Next at 2. Page 18, 19.
Oh, you are BE. BE.
Yes, my lord.
And where are you serving?
No. I'm not sorry.
You are not serving. Where is your ITR? Income tax return?
This is not
Hmm?
a next, my lord. Not a next.
You are an income tax paying since when? Not available. Bank statement will be submitted later on. No liability, no mortgage, no loan. No EMI. What did you do for your living?
I'm an agent of Bajaj Alliance,
Have you said so?
insurance company.
Have you said so?
Yes, I see.
A BE, Bachelor of Engineering, doing nothing.
Earlier, he private job.
Is it acceptable?
Earlier he did a private job, but now insurance.
Well, you should notice on this stage. Heard Mr.
ATM Hussain.
ATM Hussain Land Council for the petition. Yes. Petition, petition is prepared against an order dated 6/5/2024 and the judgment dated 24/3/2025 passed by the Court of Language, additional session judge number 3 at Nagaon in criminal appeal number in
26.
DV case number
26.
26 of 2024 and in criminal appeal number 26 of 2000. What?
26.
Same number.
24.
The DV case number. What is the DV case number?
Oh, maybe 516.
516 stroke
Oblique 22.
22 and in criminal appeal number 26 stroke 2024. DV case number passed by the Court of
Judicial Magistrate was
Judicial Magistrate First Class. In DV case number and judgment dated 24/3/2025 passed by the Court of Language, additional session judge number 3 at Nagaon in criminal appeal number 26 of 2024. From a Hussain appeal, which was preferred against the order dated 6/5/2024. From by the order dated 6/5/2024, Language Court had granted interim. It was an interim order.
Interim order.
Directed the petition to pay an amount of rupees 1 lakh stroke clear all other necessary medical expenses of the site with immediate effect. And the said order has been affirmed in the judgment dated 24/3/2025. Admittedly, the child of the petitioner, who is about 6 years of age, has vision and hearing problems. Issue notice returnable goods. The petitioners will take steps for service of notice among the respondents by registered court with AD as well as by usual process. Prepare for interim review will be considered on the return. Oh, there is no interim prayer also. Then why you are arguing?
Right.
Yes.
Yeah, in this case, Lordship, accused and victim both are before your Lordship for quashing the proceeding of special POCSO case number 34/2022, Lordship. Arising out of FIR, Lordship, dated 29/4/2022, page 17, Lordship. Initially, it has been filed by the petitioner number 2's father, Lordship, a missing report, which was later on registered by the police under section 366.
Where is the FIR?
FIR is page 17, Lordship. Particular is page 22. Translated copy with 17, Lordship. Mary, Lordship.
Okay, initially registered under
366.
Section 366.
Yes.
Okay.
Later on, charge sheet has been filed, Lordship.
Where is the
And-
charge sheet?
Charge sheet is page, Lordship, 24.
24.
It's printed copy. Vernacular is that page 27, Lordship.
366, 376.
Then added 376.
Then what happened?
Lordship, what happened?
Charge is submitted, then
Yes,
NBWA.
yes, Lordship.
You were shown as an absconder or what?
No,
In
Lordship.
the charge sheet?
I was in bail, Lordship.
Huh.
What happened, Lordship? They were in,
Yes.
they were in love relationship and out of
Okay,
this-
that I can understand.
Yes, sir.
Now, charge sheet was submitted on 31/8/2022. Then what happened? Why NBWA was issued?
Lordship.
If you are not shown as an absconder in the charge sheet?
Yes, Lordship. Kindly have a look, Lordship,
Hmm?
page 29, Lordship.
I have seen 29. It is not found in the given address and no one that locality.
Now both are residing
And
together, Lordship.
what is the birth certificate? 6.
Yes.
Yeah, what is the date of the FIR?
Date of the FIR, Lordship, is 29/4/2022.
29/4.
As per birth certificate, on that date, she was in 18 years, 13 days.
Is it?
Yes, Lordship, as per birth certificate.
Yes.
And now
If
she-
it is 18. Now what happened? They proceedings of special POCSO case number 34 of 2022. Presently pending before the Court of Landed Additional Session Judge within a special judge POCSO Kachar and Silso. The petition number, the respondent number 2, as the informant, had lodged an FIR before the at Silchar Police Station, alleging inter alia that the petitioner number 1 had kidnapped his daughter, aged about 17 years, that is the petition number 2. First, on the basis of the said FIR, Silchar Police Station, case number 1095/2022 was registered for the offence under section 366 IPC. After investigation, a charge sheet was laid on 31/8/2022, finding a privacy case for commission of offences under section 366 from IPC and section 376 IPC against the petitioner of 1. After submission of the charge sheet, and commitment of the case has been registered as special POCSO case number
34.
34, 2022, and is presently and the case is presently pending before the Court of Landed Additional Session Judge Special Judge POCSO Kachar Silchar. The special court has issued non-bailable warrant of arrest against the charge sheeted accused person, that is the petition number 1. The petition has been filed by the petition number 1 and the petition number 2 jointly on the ground that at the time of institution of the FIR, the petition number 2 was aged above 18 years as her date of birth is 16/4/2004. It is further projected that as on date, the petitioners are living together and they are expecting their child post up. Issue notice returnable in 4 weeks. As Mr. Goswami has adhered, accepted notice on behalf of West Bengal one. State of Assam, issuance of formal notice. Thus, one is dispensed with extra copy. 2 working days. The petition shall take steps for service of notice upon the informing that respondent to by registered post daily within 3 working days from today. Having regard to the projections that on the date of lodging the FIR, on 29/4/2024, the petition number 2 was measured, and as on date, the petitions are living together as husband and wife and are expecting their child, the further proceeding. It is ordered, it is observed that is observed in the interim that further proceedings of special POCSO case number so and so presently pending before the court of so and so shall remain suspended till the return.
They are not the same purpose yet by the technical.
As on that,
Submission.
the petitioner, sorry, the Mr. Goswami land petition solicitor has objected to the prayer for interim relief. Likwa hard learning council but parties on the prayer for interim relief, Travis Likwa and Goswami objected. Travis Likwa.
I live. I'm being better. Item number 5.
Yes.
Well, the petitioner here was the owner of the vehicle, and his vehicle was seized in connection with Progressive case number 72. And ultimately, vehicle has been given Jimba to the petitioner. My lord, there's 37. Only, fact is this, my lord, I have been asked to deposit bank guarantee of rupees 7 lakhs. I am not in the position to give such bank guarantee.
Yes, Mr.
So I, similar order I will do.
There is nothing wrong with the order. Only they are agreed by the amount. So yes.
7 lakh is maybe the valuation.
Can they see their pair? We are issuing about harnessing bank rent of 7 lakh and allowing the prisoner to fund it indemnity portion.
What
Indemnity portion for bank rent.
indemnity 1 hour personal government. Those judgments.
But anyway, this is. Take it over, we'll take up tomorrow, dispose of. It should be a combination of bank guarantee or.
I give any ballot, I cannot, it is not possible. Those two judgments, other judgments also there, this one will be considered, allowing the petitioner to give them their personal bottles. What order is it?
Bond with two,
I will.
no, it will be a condition, he
Yes,
cannot
I will-
sell, he has
I
to
will-
produce.
Yes, my lord, I will.
Think
put
it over, or it is a combination of bank guarantee and bond. 1 lakh bank guarantee, 6 lakh bond. Yeah, Amit. Please take us to. Motion to.
For admission, item number 21.
Sort of, something.
Okay.
Reported, my lord, the office note indicates, my lord, the record of the ATM Tinsukia was confirmed. That has not come, my lord. It
Has not been received, okay.
LCR is because case number 35 of 2.
So let us await for LCR. Mr. S. Count, learned counsel for the petitioner. Right. And who is RJ Boro? An additional public prosecutor for the respondent number 1, State of Assam, and Miss H. Jain, Land Council for the respondent number 2, 3, and 4. Poster. Peruse the office note. Dated 21/7/2025. Poster. Await for the TCR. Poster. Miss So-and-so has also sought for accommodation. Poster. Lays the case after 2 weeks for TCR. But any interim order
No, there,
till disposal?
may I pray for a day after 50.
2 weeks, 2 weeks.
Item 23.
Huh?
I'm very corresponding number 2, madam. Can we take up tomorrow, madam?
Not tomorrow, we have already fixed 2, 3 members. Yes, any other date, next week? Or next week then?
Next week, yes.
Okay, next week. July. Then next week, Friday, 1st of August.
Madam.
Okay, Mr. A.K. R. Chauhan. And Mr. Petitioner and Mr. R.S. Mishra. Council for the RS number 2 at the end. Mr. Any state council? Or state you are the group. Response number 1, still on the prayer of Mr. Mishra and Council for the response number 2, list the case on 1st of August. As the prayer is not objected to by Mr. Chauhan and Council for the petition.
Item 27.
Appeal. Criminal appeal.
Passport binding maximum is an
Stands. Mr. Goswami, what is the order? I could not understand. I don't. There is only one order. I could not understand. Something wrong. Looks like something wrong. If it is CR case number.
Was fixed. Well, 2 counts for where the appeal was allowed. The trial court convicted the person, trial court appellate court allowed on 2 consent. That it was a blank check and my lord, presumption cannot be held. It was given as a security. And that too, my lord, has been settled by the Supreme Court in 2023, that even in a blank check, presumption can be taken care of.
So you were the complainant.
I am the complainant. My lord, and on the very trial court convicted the respondent. And my lord, at page 45, your lordship will find,
Right.
I was the complainant. Trial court,
Third of two. Wait, there are other petitions or what?
well, that was a leave petition, my lord, because of the present situation, leave has been dispensed with. Because
Oh. Mr. Gusami, there's something wrong with it. That was in the leave petition that order. Okay. So this is to be admitted.
admitted.
First admitted,
Admitted.
listed for admission here, you cannot. Heard Mr. P.K. Roychud, and also for the petition, and Mr. M.P. Gusami, and additional public prosecutor for the respondent number one, Kama State of Assam. This criminal appeal is preferred under section 378 within bracket 4 CRBC. Come after obtaining leave, come after a sale. A judgment and order dated 19/8/2023 passed by the Session Judge Kamrup Metro at Guwahati in criminal appeal number 18 of 2022. Postal. By the judge, impugned judgment and order dated 9/8/2023. The Session Judge Kamrup Metro Guwahati, as the appellate court, has allowed the criminal appeal, thereby, setting aside a judgment and order dated 23/2/2023, passed by the Court of Learned Judicial Magistrate First Class Kamrup Metro Guwahati, trial court bracket, in complaint case number 6907/2018. First of, the complaint case was instituted by the petitioner and the complaint against the respondent number 2 as the accused for committing an offense under section 138 of the negotiable instrument. As the criminal appeal was allowed, the conviction and sentence passed by the trial court has been set aside and passed. I've gone through the contents of the memorandum of appeal. The criminal appeal is admitted for hearing. The case records from the learned trial court and the appellate court we call for. Issue notice returnable in 2 weeks. As Mr. Kusami learned additional notice, appear and accepted notice on behalf of the respondent one. Or state of Assam, issuance of permanent notice plus respondent one is dispensed with. Extra copy memo with 2 working days. The appellate shall take steps for service of notice. Upon the respondent number 2, by registered post to TD as well as by usual process within 3 working days. Appellant over, now this what appellant.
Item 29.
Some prayer was made morning or what? Yes.
I'm actually on behalf of respondent. A matter may be adjourned for today, time may be granted for filing. Objection.
Objection. Miss,
Oasumi.
Land Council for the petitioner is present. Miss,
Lordship, may kindly fix a short break.
Miss,
As does on behalf of the nation.
Miss, as does Land Council appearing on behalf of Chief Minister of Land Council for the respondent has sought for and is granted 2 weeks time to file an objection. Closed up. Place the case on suspension.
Lord, as regard item 33, Lordship, I filed an IA for vacation of the stay order, Lordship. I am on behalf of the wife, Lordship. He is
On
not-
it, what is this 655? You were there in 655?
IA 687 of 2025, Lordship.
No, in which criminal revision petition?
158 of 25, Lordship.
Okay, let us see. 655. You were the petitioner here.
Lordship,
In item number 32 also,
655, Lordship, I have the petitioner.
you were the petitioner. Let us see, issue notice.
It's for enhancement of the maintenance.
Appeared. It appears that we also.
They have not.
655.
Await service report. As part of his.
He in Mazumdar. Issue notice. Are you appearing? In item number 32? Okay.
I served already the copy, Lordship.
Are you representing Mr. B. Asaiji? The respondent are same.
Same, Lordship. Same there. And even in item 33 till date, we have no service was there, but I obtained the certificate copies and filed by Wakalatoma, then I filed Lordship.
Prithviraj Das.
Lordship.
Are you representing Prithviraj Das? Huh? Why you have no instruction to appear in item number 32?
Not received any copy yet.
But Mr. Mazumdar was directed to serve a copy.
Lordship regarding IAL.
No.
Because in the office note of item 32, Lordship shows that the await service report.
No,
Office-
sir.
Lordship is that. It's if I got 25 office note, may kindly.
But subsequent to that,
IA.
no formal notice is required to, as Mr. B. Asaiji Learned Counsel already appeared in the matter. It appears that Mr. B. Asaiji Learned Counsel for the petition in the accompanying criminal division petition number 158 of 2025 is absent today. Mr. Mazumdar shall serve a copy of the petition to Mr. Asaiji for the respondent. Extra copy of the application.
Application.
One is petition, one is application.
Petition.
So
of
have
the-
you served them?
Lordship, I have served, because she was not.
Now,
I in presence. this
madam
amount of-
is saying no copy, no instruction.
Lordship, I am serving the copy of the IAL, Lordship.
No, in the, see the call list.
Lordship,
Respondent side is blank in item number
Lordship.
32.
I'll serve tomorrow, Lordship, that copy of.
You served the copy
Lordship, surely, Lordship, because I have urgency, Lordship. stay
in
order
terms of
to them.
the order dated 24/6/2025 by tomorrow
Lordship,
in item number 32. Now, what do you say about 33?
33, Lordship, I pray, Lordship, because the entire blanket stay order was granted by this honorable court, Lordship. she is not getting any maintenance, lordship.
Okay,
If
what
it-
do you say about the I? Oh, you have received copy.
Lordship,
Okay,
lordship-
then on the next week, on a fixed date.
I pray lordship with the urgency, it may be
Okay, on a
Friday.
fixed date, you have just handed over the copy.
Lordship do. No problem, lordship.
At least there should be given some
You-
opportunity to
Lordship.
file an objection if they so desire.
But one thing is.
Okay, 1
Lordship,
minute. K.
I- they are
Mazumdar,
submitting,
Learned
lordship.
Counsel.
They have not taken
Let
it.
me dictate the order. If you
Lordship.
want any addition, we'll add
No,
that. Learned Counsel for the petitioners in both the petition, both the cases. And Miss M. Asaria, Learned Counsel for the respondent in 33. Number to keyboard, criminal revision petition. Also. Mr. In criminal revision petition number 655, 2025. An order was passed on 24/6/2025, directing Mr. Mazumdar, Learned Counsel for the petition, to serve a copy of the petition to Mr. B. Asaiji, Learned Counsel, who has already entered appearance on behalf of the same respondent in the accompanying criminal revision petition number 158/2025.
They are the petition number.
Postum. On query, Mr. Mazumdar has submitted that he has not yet served a copy of the revision petition in 6/55/2025 till date, postum. And he has undertaken to serve a copy of the revision petition to Mr. Asaiji by tomorrow, postum. Para. The interlocutory application, IA criminal number 687/2025 has been deferred, seeking vacation of the interim order passed in criminal revision petition number 158/2025. Postum. It is only today, a copy of the application has been served to Ms. Asaiji, Learned Counsel for the respondent. Postum. List. The respondent stroke opposite party in IA criminal number 687/2025 is granted a week's time to file an objection, if so advised. Postum. List the cases on after 1 week. Done?
Lordship, that may not be lordship, it was very technical, only for.
The interim order passed in
Lordship, I
33
kindly.
shall continue till the next date of estimate.
Because it was returnable date already over, lordship. It was only for till returnable date. That returnable date, lordship, that matter was not listed. Kindly pay.
Then it is, if it is not listed, then it is to be
No, Lord, not
extended.
listed, but lordship, at my instance, lordship, because.
Then you withdraw this vacation order. Interlocutory application. You withdraw, no purpose.
Actually, they have not served any
Next.
copy to us.
34.
Search sheet,
Charge sheet and the FIR, lordship.
FIR,
Lordship. Lordship, the,
returnable 3 weeks.
and lordship. In this case, lordship, the petitioner and the
File
respondent number 2
proceedings.
is the husband and wife, lordship. And initially, lordship, and prior to their marriage, lordship, the informant, respondent number 2 laws and FIR. And subsequently, they get
You are
married.
enjoying stay, whether respondent number 2 has appeared.
And even then, lordship, the respondent number 2 already filed an affidavit, lordship, and the notice page number, lordship, 29. And they are continue their conjugal life as a husband and wife, lordship, very happily, lordship, now. And prior to solemnize their marriage.
Yes, Mr. You file a 1-page affidavit. Should that compromise or settle or whatever? Huh?
Page 30.
30?
29 and 30 is operating person.
Yes, it is not an affidavit. If something goes wrong, responsibility will be fixed on you. That is why I need an affidavit from you. Because I have experience. By tomorrow you can file.
This is the original document.
Let him file as a counsel of the respond number 2. Then we'll exercise our inherent power. Offense is what? I don't know. 69, I don't understand. What is that?
Sexual intercourse with the.
Oh, 376.
Item 55.
It's an application for crossing of an acquired.
What was the issue here?
Issue is lordship, after marriage lordship, the petitioner married, got married to the
See, copy of the search sheet. Not annexed, that is why. To decide the application, we need the scanned copy. Okay. Without any submission from your side, Mr.
No,
Name,
Iceland.
Islam. Now counsel for the application. And Mr. S.H. Bora, Learned Additional Public Prosecutor. Respondent state. Also. A vehicle being registration number AS-28 AC -1322 within bracket Tata 6-wheeler 1512 LPT truck was seized on 5/11/2024 in connection with Delhi Police Station case number 49 of 2024 under sections 21 with a small c stroke 25 stroke 29 of the NDPS Act 1985. Poster. The petition has claimed that he is the owner of the subject vehicle. Poster. After completion, a charge sheet has already been filed in connection with Delhi Police Station case number 49/2024. Within bracket corresponding GR case number 268 of 2024. And the case, NDPS case number 34 of 2025 is presently pending before the court of Special Judge Karbi Anglong, Dipu. Poster. As a petition filed by the petitioner seeking custody of the subject vehicle has been rejected by the Learned Special Court by an order dated 9/6/2025. A petitioner is before this court by the instant criminal commission. Assailing the said order. Issue notice retardable on so and so. As Bora accept notice. In order to give consideration to the instant application, scanned copies of the case records of NDPS, case number so and so would be necessary. The registry to requisition, that scanned copies of the case records of so and so. Miss Bora, if this court sits on 6/8, I don't know the roster. Then I am fixing all the NDPS case vehicle custody on a particular date. Be ready with all.
6/8.
So many orders. Yep. Yep. If some urgent orders. Or otherwise I'll hear Mr. Bora. Some 2012 or 13. Year 2012 or 13. 12. So in comparison to that, is there any urgent case? Orders are given. If there is something, we'll fix on Monday or Tuesday or Wednesday.
Let me 50 mailer. You fix a date.
Okay, 40 লিখে রাখো, date এটা দিব next week. 49 next week.
First and second list of.
You need in August. On the Mr. H. Chauhan, and conservative petitioner is present. Sought for release the case on August or DD button. First week or 8th of August?
Yes.
8th of August.
Hello, my native is 39. Can it be on 28th of this month? On Monday?
Wait, okay. Miss N.S. Thakurial and a conservative petitioner is present and sought for release the case on 28th. 7. 28/7. Otherwise,
Yes.
no urgency, don't make prayer. Exercise your reasonable mind,
There is some
and if
emergency.
really there is urgency, make a prayer.
There is some emergency. It may be taken up on Monday, Mala. Item 51.
What is this?
Item 51, Mala.
This is for what? I is for what?
Is for delay of 119 days.
190 days. Conviction is
Is for negotiable instruments. NI
Act.
She has already gone for custody matter. So there,
How
that's
much?
urgency, 3-4 months urgency. But now she's a government employee, so her pension.
Government employee
Yes, ma'am. That is the seriousness. of the
undergoing custody in NI case.
Yes, ma'am. That is the main seriousness of the case.
How much is the amount?
17 lakhs.
17 lakhs.
That is being the urgency.
Srimati Jonatha Raskwa.
To make this prayer, madam.
Okay, on the prayer of Miss D. Sinha, and conservative petition, release the case on Monday.
Deeply outlined.
Let's see, item 45, let's see, can be fixed. It possible on 28 or.
Why this I?
I is for bail. Lord.
Bail.
Yes.
Okay. NI Khan. Wednesday.
Must. Lord check, item number 50, Lord check. The IA is for convolution of delay for 81 days. 81 days, Lord check. Only maintenance of all the judgment of the family court.
Okay. Criminal revision petition.
Yes, yes, Lord check. 50, thank you.
Next week. No, Wednesday.
Even Monday. no?
Yes, the guy. Oh, already. So many cases have been fixed.
Monday.
Wednesday.
All, I do this.
Wherein I am hearing to the respondent, your lordship, not know who is the counsel for the petitioner, I have not been able to find it.
This is for, I for, is for what?
It's filed for confirmation of delay, wherein the.
You have no objection.
I'm the decree holder, your lordship, so he's not complying with the decree over there.
If you say no objection, I am allowing it.
Yes, but without delay confirmation, let him at least make a payment, because in the last 2 years, he's absconding from the family court.
Who is the council?
I do not know, your lordship.
Item number 40?
47.
Yes. Where is Mr. G Uddin? Yes. No objection. Allow. Yeah.
Subject to some amount of penalty losses. There's a.
No, delay, it is delay
Yes,
in the criminal, no, in the criminal revision petition at the time of admission, you make a submission on the strength of section 141 or 143. That this has to be admitted, at least giving deposit of so and so. You make prayer. So far, how can,
that I would ask
in-
for specific options. That I
how
would-
can in the condemnation of delay, I can give you 1,000
What's it?
as cost,
There's a child in.
42 days.
There's a child
But-
involved. Then he refuses to appear in the family court.
Enact, right?
No,
You-
family court, family.
Okay.
There's a maintenance decree and a permanent alimony decree.
For the timing, 1,000.
So that is,
Just 1,000 is a cost for delay. Agreed. Heard. Miss POD carry, Learned Counsel for the applicant petitioner, and Miss R. H. Chaudhary, Learned Counsel for the opposite party as respondent, post of the Eastern application under section 5 of the Limitation Act 1963 is preferred, seeking condonation of delay of 42 days, which delay stated to have occurred in preparing the accompanying criminal revision petition under section 438 and section 442 of the Bharatiya Nagaric Puraika Honita 2023 against an order judgment dated 6/11/2024 passed by the Court of Learned Principal, passed by the Principal Judge, Learned Principal Judge, Family Court number 3, Kamrup, Metro, Guwahati in FC Criminal Case number 389 of 2022. Post of by the order dated, judgment dated 6/11/2024, the Learned Family Court has directed the petitioner to pay an amount of rupees 8,000 per month to the opposite party on a petition filed under section 125, CRPC. I have gone through the statements and amendments made in the instant interlocutory application, more particularly, paragraph 3 and 4 thereof. Where Ms. Chaudhary, counsel appearing for the opposite party, has submitted that since the judgment was rendered on so and so, the petition has not paid any amount to the opposite party. Ms. Chaudhary has, or is also fair in his submission that if the opposite party has no objection, if the accompanying criminal revision petition is heard on merits after pondering the period of delay. I have gone through having regard to the statements and amendments made in the instant interlocutory application. This court is of the view that petition has been able to show, has provided certain explanations for the period of delay. As the matter is, as the subject matter in the accompanying the criminal revision petition is provision for monthly maintenance, this interlocutory application is allowed subject to deposit, subject to payment of a sum of rupees 1,000 as cost to the opposite party within a period of 7 days from today.
one small point,
List the
copy of the criminal revision that now be served upon you, because I already have the IA as well.
okay, the raise the office to list the accompanying, registered accompanying, criminal revision petition and thereafter to list the case, list the same. Full stop, the learned counsel for the applicant petitioner shall furnish a copy of the accompanying criminal revision petition to Ms. Chaudhary, learned counsel for the opposite party, the petitioner, at the time of payment, making payment of the sum of rupees 1,000 in the form of a check, account pay check.
But it has check it or bounce once, so check will not be. By the case, look. Unfortunately, the
In
lady
cash.
does not have money to file an NIK.
No, well, I thought that,
Otherwise it's
no, cash will be difficult on your part to receive, right? That is why account pay check. Then we'll hold petitioner.
One small prayer. The man has been absconding from the family court. I mean, he does not appear before the family court since last May. Now, this petition also, if you also see his address, we are not being able to trace him out, Your Worship.
That we'll see at the time. We are all conservation of delay.
Address me for how is this petition being accepted without a proper address, Your Worship?
That I don't know. I'm not the receipt.
They may be allowed, they may be.
You raise this point when the criminal revision is taken up,
Gotcha.
not in conservation delay.
Gotcha.
Also, the item number 50, notice may be issued also. Item number 50.
We posted it.
Yes, Lordship,
That's
there,
another day.
some outness there, Lordship. Yeah, already it will be one step ahead, Lordship.
No, it is not. Sometimes I do not issue notice. I simply condone the delay.
For the revision petition, Lordship.
How much delay?
It's 81 days, Lordship.
You may condone also. Without issuing notice, because matter of condonation is between the party and the court.
Oh, yes, Lordship, but Lordship, the bench will be the difference in the next week.
I don't know.
That will be the difficult, Lordship.
I don't know.
Hello.
Lordship, item number,
Court cannot go on ifs and buts. Yes.
item number 56, Your Lordship, this is a
What?
fixed matter, Your Lordship. Matter will be
Everything is fixed. No case is unfixed here.
matter will be
I have
taken-
seen the cause list. Everything is fixed.
Yes, Lordship.
This is for what?
Orders, Your Lordship.
You were there that day.
Yes,
Are you ready?
yes, Lordship.
Condonation.
Yes, Lordship. 364 days delay.
Okay, 360. And you are undergoing, you are in custody or what?
Yes, Lordship.
What is the period of custody?
5 years, Your Lordship.
Already spent 3 years.
9 months, Your Lordship.
Yes, that was the case. I think. IA is for?
Delay condemnation and
Okay.
suspension of petition.
Mr. Bora can't help it. Yes, tell me.
Lordship, there is a delay of 364 in filing this criminal appeal, Your Lordship. There is no deliberate negligence on our part, Your Lordship.
What is the offense? Offense? Section 10.
Convicted under
POCSO.
10 of.
Let us see. Appellant has preferred the accompanying criminal appeal to assail a judgment and order dated 22/9/2022, passed in connection with special reading back at POCSO case number 50 of 2021 by the Court of Learned Special Judge POCSO Siva Harbor. By the judgment and order dated so and so, the applicant appellant has been convicted for the offense under section 10 of the POCSO Act. And he has been sentenced to undergo rigorous imprisonment for 5 years and to pay a fine of rupees 5,000, in default of payment of fine, to undergo rigorous imprisonment for 3 months. Mr. Goswami, do you have the copy of the memo of appeal?
So that is.
Huh?
With the record.
Not with the record. This is a serious case. 3 years means bail is also
Yes.
will be statutorily.
And Yesterday,
Yeah,
that
this-
Deeply up.
Ah, madam is not.
Yeah, please eat.
36A, is attached with the half of.
No, but period is to be condoned first.
Limitation.
So appeal, and you remember, I may not be there.
36A.
You press for your bail.
Only I will objection regarding limitation.
If instead of you, if it is Mr. Bora, I would not have said so.
I will objection regarding personal period.
Though Mr. Gustami has raised certain objections, comma, in view of the above fact situation obtained the case, comma, and the same does not appear to be acceptable.
Deeply applies.
Yes, Mr. Bora.
May please, Lordship, item number 43. In this matter, Lordship, service report are awaited and stay has been granted by this honorable court by order dated 4/12/2024.
Item number?
43, Lordship.
Yes.
Service reports are awaited and a stay has been granted by this order dated
Sure.
4/12/2024.
In criminal matters, nobody leaves his ground. 43 due. Depending, outside yourself, not so next to me. But check.
Much obliged, Lordship.
You are appearing in which? Yes.
See, before placement calls for some.
M. Sharma, Direct Counsel for the petitioner, and Mr. MP Gustami, and addition for the prosecutor for the aspect number 1, from state of summer present. Post of. Page the office notes dated 19/7/2025. Await for the service report in respect of the respondent. Okay. Service has been complete.
Yes, sir. Service has been performed.
Scan to be received. As per office note, comma, the notice has been duly served upon the respondent number 2, post of. As none has appeared for the respondent number 2 till date, comma, this court deems it fit to grant another opportunity for the respondent number 2. Respondent number 2 to enter appearance. This is the case on so and so date. We are granting another opportunity. 43. Here, join. Service report. Okay, 21/7/2025. Okay. May not be able to
Yes,
complete also.
I'm gonna, I'll make it short, Bilal. Only the point which your lordship raised yesterday, Bilal. There are two judgments of the railway, other than railway, Bilal.
On this point, I think 2-3 judgments.
Basically two
Have-
judgments. One is Balakrishnan Devilar, that's what, which your lordship has yesterday referred to. And you do that the state of issue versus Durga Prasad. These two.
Prior to that.
That is in 75 and this is 80. Now this, both the judgment hold the fields, Milord, due to Milord, coming of this Tufan Singh case, Milord. Now if you
Tufan
want
Singh, I have, with respect, subject to your submission. I have checked Tufan Singh. Only 2-3 judgments have been overruled. But because the question before the Tufan Singh is regarding 67 statement, right?
Statement, but
There are certain differences in both the acts.
But your lordship, kindly see the paragraph from what it said. It has been discussed regarding these two cases, paragraph two, because
Discussed at many places.
no, many places, but the result, your lordship, what the, my lord, you kindly see,
But that is a
120, just paragraph 129 and 130. Hey, I have give the book list because it's a voluminous, I could not, 129, paragraph 129. It was started from 122 onwards. Balakrishna Devila started. Ultimately, what has happened in the discussion, my lord, 129 and 130 below. It was discussed everywhere. Lordship, kindly just two paragraphs only, 129 and 130 below. It starts from 122. It has been what this Balakrishna judgment and my lord. Yes, please. My lord, and Durga Prasad case, my lord. Now,
120 paragraph.
paragraph 129. My lord, this is 128. The chapter, what has been said, what is the say? The golden, my lord, what is it? There's a narrow spec and a broad spec has been said. One, the golden thread running through all this decision. Some of this being decision of 5 judgments which are binding upon us, beginning with Barkat Ram, is where limited power of investigation are given to officers primarily or predominantly for some purpose other than the prevention and detection of crime. Such person cannot be said to be a police officer under the section 25 of the Evidence Act. What must be remembered is this discussion in Barkat Ram that a police officer doesn't have to be a police officer in the narrow sense on being person who a police officer so designated attached to a police station. The broad view has to be accepted and never dissented from in all aforesaid judgment, namely that where a person who is not a police officer properly so-called is invested with all powers of investigation, which culminates the filing of a police report, such officers can be
This
said.
word, you remember this word, police report.
My lord, no,
Okay.
yes,
Just remember this.
yes, sir, there are. Police report, such officers can be said police officer within the meaning of sections 25 below. It was distinguished 25 below of the Evidence Acts, as and where they prevented and detected crime, they are in a position to extort confessions and thus are liable to achieve their object through a shortcut method for extracting involuntarily confessions.
So
Now that 128, 129 and 127 is
See.
clear.
no, clear. What does section 9 says?
My lord,
It is summon.
right, my lord.
Summon.
It was discussed,
No.
everything has been
No.
discussed. Well, yes, my lord.
Discussed. I have also gone through yesterday.
My lord.
It is not that I have not, I have also gone through.
I know your lordship will go.
But see the last but one of the majority judgment.
Yes, last but one, that is,
Last but one.
that is on
paragraph.
67. my lord. That is on 67.
And what cases are overruled?
That is, but overall is,
You see the first, do you have the book also?
yes, my lord.
Okay, come to page.
Yes, my lord, it will be, my lord,
Come page to 37. 37.
one,
Only page 37.
only purpose.
See CL number 16. Right.
37.
Page 37.
Uh,
CL number 16.
CL number 16. Overruled.
16.
Yes, overruled.
Overruled. Then page CL number 55 at page 39.
My lord. Overruled.
Right. Then CL number 84. Partly. Then
partly.
100.
Well.
Partly. Right. Now come back to serial number 59.
Yes, my lord,
There
59
is
is that.
nothing, right?
My lord.
And 66,
Yes.
Durga Prasad,
Durga Prasad.
nothing. Now, if you paragraph 150. NDPS.
$150. Basically, quota and Customs Act.
No, please, paragraph 150, paragraph.
158. my lord.
Paragraph.
150, yes. 150 is
And railway act.
what to be considered in Kanailal's in the judgment of the questions revolve around.
No, 158. Paragraph, we answer the reference by stating.
Yes, ma'am. The officers who are invested with a power under section 53 of NDPS Act are police officers. It's clear. There's
No,
no,
yes, under section 53 of NDPS.
yeah. What is the meaning of section 25?
Now come to page paragraph 122.
Yes, 122 is where from it started. This the Balakrishnan case. These are 122, 123, 124.
Yes.
It started exactly coming to 128. All this up to 128. Up to 128. Balakrishnan's and the Durga Puja case has been coming. Now, these are the paragraph 129 and 130 are the paragraph which they say, it says, because
Paragraph 125.
most importantly, the Balakrishnan so and so, it was Malad quoted.
Let us read.
Yes,
Let us read.
Malad.
Understand.
Yes, Malad. 37, sixthly, the primary duty of a member, officer of a RPF is to safeguard and protect the railway property. Only such power of arrest and inquiry have been conferred by the 1966 Act on the members of the RPF as far as necessary and incidental to the efficient and effective discharge of basic duty of which and what. Unlike a police officer who is a general power, unlike the court investigate all cognizable cases as power of the officers to the RPF to make an inquiry is restricted to an offence under 1966 A.
Now, two paragraphs are quoted.
Yes,
these are very important.
Yes, quoted.
Paragraph 39.
This paragraph 38.
Last line, the character of the inquiry is different that of an investigation under the code. The official status and powers of an officer of the force in the matter of inquiry under section 166 Act differ in material aspects from those of a police officer conducting an investigation under the code. So from this Tufan Singh, there is nothing in your support.
But
ratio,
but
residendi. But ratio residendi. You have to extract your benefit only out of that.
Malad, no.
Pal Kisan itself.
My.
I think if I have understood Pal Kishan correctly, then answer lies there.
My lord,
if you have gone through.
But I have not gone through the Balakrishnan.
No, you have to go through Balakrishnan. I think answer lies there only.
What my submission is this, but it's clear why discussing everything, Milord, this court has held.
Obiter cannot be taken.
But
there is a difference between ratio, residency, and obiter.
Yes, Milord, but it has to be read continuously. We cannot take it partially, Milord. If
So,
you take it continuously, then paragraph.
whether the question before the court will be done,
My lord.
because these observations are, Balkishan are completely different, and they have taken up the issue in, the state to fund regarding another aspect. But while discussing, they have discussed.
Discuss.
And it is not overruled. Only 4 decisions have been overruled.
Robert,
Right.
as well.
Because the question before the court is only that. And this is obiter.
But if your lordship,
Obiter cannot be taken as a ratio.
my lord, if your lordship,
But
what?
Mr. Bora,
Yes.
that is why I am saying, having a glance at Balkishan,
Well,
I think answer for adjudication of this criminal revision petition lies there only.
but.
Yes, we have learned.
Well, no, in fact, I am also learning, my lord. It's not that.
We have learned. That is why I said,
Sir.
I said, we have learned.
Uh,
But question is the answer perhaps.
Maybe, my lord, your lordship is correct.
I did not get that much of time, but answer lies there.
Hmm.
And in one paragraph yesterday I have seen that this question is to be answered perhaps in the interpretation of article 20 within bracket 3.
Which in paragraph one.
That has to be examined.
And that is why, my lord, if your lordship can see paragraph 130.
Perhaps there are 3 conditions. Balkishan. Have you read?
Balkrishnan,
I think you should better read this. This is also an interesting one. I have not totally gone through, but it appears that the question for this revision petition can be answered on the basis of Balkishan itself. Subject to Mr. S.C. Mr. what to say, because 3 conditions are required. Because you have pointed out, I think there is a police case.
My lord, there is a police case, my lord.
This man was arrested
Arrested.
in connection with that case.
How could that be? Thereafter, what has happened, my lord?
Thereafter, the materials, because it was on the basis of an FIR lodged by Oil India.
My lord, Oil India.
Our pipes were stolen.
Stolen. Now, what they say, no, they have not said our partner. They found that sufficient, they get a truck to be, the pipes are from the Oil India.
And with those pipes, certain additional stolen, suspected stolen items were there.
Now,
those were seized by a CGI list, by railway police. On 6/2.
well,
I think this man was forwarded to the police, court on 5/2 perhaps.
well,
So go through 3 points discussed in Balkishan. And if it says, if all the 3 are found satisfied, then exhibit 18 cannot be reviewed. Only that 3 conditions.
and apart from that also, my lord,
Plus,
if your lordship kindly,
second, next issue is that it is not because settled or proved, established.
that these are stolen from the railways.
That is,
That-
these 2.
That is,
Because our scope is also limited.
right, my lord. Now, if your lordship kindly, what I just want to emphasize, paragraph 130, my lord. What 130 says, my lord, it's a continuous of, your lordship will find 122 onwards, my lord. The entire 2 cases has been discussed with, my lord. Now, the findings are because it is regarding the cases of LDPS, basic LDPS. Now, while discussing, these are the cases, my lord, 129, they have come to this 129, the paragraph 129 and 130 below. Now what 130 says, 129 says is that, and 130 says,
Mr. Bora, let us read paragraph 135.
Right.
Read slowly.
despite of the fact Rajkumar Karwal noticed the fact the NDPS Act prescribes offense which are very severe, and that section 25 is a wholesome protection which must be understood in broad and popular sense. Yet it arrives at a conclusion that designated officer under section 53 of the NDPS Act cannot be said to be a police officer under section 25 of the Evidence Act. The division bench also noticed that unlike the revenue and the railway protection statute, where offences are non-cognizable, the NDPS Act offences are cognizable. It is also noticed that the NDPS Act deals with the prevention and detection of the crime of a very serious nature. However, Rajkumar Karwal did not properly appreciate the following distinction that arise between the investigating power of officers who are designated.
This is the distinction.
So it's a distinction.
Between the investigative powers of officer who was designated stated primarily mean for
Primarily
revenue
mean
and
for the
railway
revenue
purpose.
or railway purpose.
Ah,
As against officers who are designated under section 53 of the NDPS Act.
Six differences.
Well, everything.
Let us read.
That section 53 is
Because however, Rajkumar Karwal, right?
yes,
So this is the version of in Tufan Singh.
my
This is the finding reached by Tufan Singh.
lord.
First, see,
My lord.
six differences. First,
My lord, then Rajkumar Kanwal do not properly appreciate the following distinction that arises between investigative power of officers who are designated in statute primarily meant for revenue or railway purpose, as against officers who are designated under section 53.
so these are the differences which have been recorded by Tufan Singh.
Tufan Singh
Read.
of NDPS Act. First, 53 is located in a statute which contain provision for prevention of detection and punishment of crime a very serious nature. Even if the NDPS Act is to be construed as a statute which regulate and exercise control over narcotic drugs and psychoactive substances, the prevention, detection and punishment of crime related thereto cannot be said to be ancillary to such object. But it is the single most important and effective means of achieving such object. This is unlike revenue statute, where the main object was due realization of customs duties and consequent ancillary checking of smuggling of goods, as Land Customs Act 1924 or Sea Customs Act 1970 and Customs Act 1962.
Or
the levy and collection of excise duty as on centralization, or as in railway property, Unlawful Possession Act 1966. The better protection is the security of railway property. Second line, like the Revenue Statute and Railway Act, all the offences to be investigated by the officers under the NDPS Act are cognizable. Third, that the section 53 of the NDPS Act, unlike the aforesaid statutes, does not prescribe any limitation upon the power officer to investigate an offence under the Act. Therefore, it is clearly all the investigating powers vested and an officer in charge of a police station under the CRPC, including the power to file search sheet, are vested in the officer when dealing with the offence under NDPS Act.
this is wholly.
This is wholly distinct from the limited power vested in officers under aforesaid revenue and railway statute for ancillary purposes, which have already been discussed by this court in Barkhat with reference to the Land Customs Act, Bakato Jyoti, with reference to Sea Custom Act, Ilyas, with reference to the Custom Act, Durga Prasad, and Balakrishnan, with reference to the Railway Act. to be aid the domain of the object stated in question, which are already alluded to, were not primarily concerned with the prevention of detection of crimes like NDPS Act.
So
My lord,
by this discussion,
my,
Tufan Singh differentiated
yes, my lord, the railway
NDPS Act with all these revenue and railway case,
cases,
right?
but they have observed that.
No, the distinction has
This is-
6 distinction,
My lord,
not 1. Then they have differentiated
my lord,
and the power.
yes, different. So by
So
which?
now if you
By
now
which?
if you go to, because
Yes.
that is what I cannot lay down the law.
No,
This is not that easy. Something will create havoc.
no.
Now,
Eight inquiry, my lord.
this has been discussed in detail in this bulk issue,
Bulk, sir.
right? If you go now, also importantly, see next one line.
No. Also importantly, none of those statutes,
Those statutes means
Those-
railway.
those statutes recognize the power of state police force to investigate offense under those acts together with officer mentioned in those acts, as the case in NDPS Act.
So
No question of manifest arbitrary or discrimination on the application under Article 14 of the Constitution would therefore arise
in those cases.
in those cases. My lord, unlike the case which arises under the NDPS Act as discussed in the paragraph 70 and 73 herein above. My lord.
So it has taken
Yes.
out all this.
But if your lordship kindly see 130, my lord, because it's the
130 because I have said to shortcut,
Yeah.
because 135 is after discussion made in paragraph 130.
But
That is
130
the difficulty.
But if you look at 130 is very clear in the sense. So, well, if you see 130, what 130 says, paragraph. They have discussed, my lord. 129 and 130, my lord, especially, my lord. Though, yes, my lord, your lordship is very correct, my lord, they have distinguished NDPS Act and other ancillaries act, which has been empowered by the statute itself. My lord. Now they have distinguished. These are the NDPS and these are the other ancillary acts which has been listed.
Then they have gone on to discuss Kota, Tada.
Everything.
Then there they find similarity.
130 minutes, if you I just read this 130 minutes, just to refresh the mind. What 130 paragraph 130 say, the Sri Lekhi's assault on Raja Ram Jaiswal, stating that it is wrongly decided and ought to be held to be par impurium, cannot be countenanced. Raja Ram Jaiswal correctly decided the court of Barkhat Ram had held that the word police officers to be found in section 25 of the Evidence Act are not to be construed in a narrow way. The word which is said narrow way. But in a wide and popular sense, it is wholly incorrect to say from the strained reading of Barkhat Ram that in reality, the contrary to the understanding of several judgments of this court, which refer to the Barkhat Ram and which continue to adopt the broad and not narrow test laid down in the said judgment. Also, Rajaram Jaiswal has referred by several constitution bench of this court and has been pointed out by us herein above as also other division benches and has never been doubted. In fact, it has always been distinguished in revenue statute cases as well as in a railway protection case as being a case in which all powers of investigation which would lead to filing of police report were invested or excise officers who therefore, despite not belonging to the police force properly so-called, must yet regard as a police officer from the purpose of section 25 of the Evidence Act.
Distinguished.
So it is clear, my lord, so far.
No, in fact, it has always been distinguished, right? Distinguished, don't leave the word distinguished.
My lord,
In the revenue statute cases as well as the railway protection force cases, as being a case in which all powers of investigation
Yes,
which
Lord.
will lead to the filing of a police report were invested with excise officers. Excise officers who therefore despite not belonging to the police force, properly so called, must yet be regarded as police officers for the purpose of section 25 of the Evidence Act. The vital link between section 25 and such officers then gets established, namely, in the course of investigation, it is possible for such officer to take a shortcut by extorting confession from an accused person. These are excise officers, and they have been distinguished from railway protection force. But if you are stressing on paragraph 130,
well,
that is revenue statute and railway protection statute.
my lord, yes, my lord,
If
that,
I read it again, it is the excise officers in Raja Ram Jaiswal or Barkatram, sorry,
Barkatram.
that they have been invested with all the powers of police officers. So for them, section 25 will come. But that is a distinction. Railway protection force and so I have keep through, Mr. Bora, to be fair, and I find that Tufan is not very much in recording a categorical finding.
But no, but your lordship, I
Not
need,
there.
my lord,
I'll
if you
read
take
again.
as a whole, my lord, your lordship, can you see, these are the statute, the NDPS is the hard, well, a very hard statute, it has been made.
No, this is not hard. NDPS is hard.
Hard, I am not saying that, that is what I am saying, NDPS. The
Mr.
court has gone,
Bora, you please read, go through once again. Tufan. Because it is an interesting case.
definitely, my lord, that is why,
But at the same time, Balkishan, instead of laboring in Tufan Singh,
if I go to Balkishan,
I think their answer would lie there. My feeling. I have to read again because so many things have been written in Tufan.
my lord, yes.
It is very difficult.
Difficult, my lord, distinguish, my lord, I have gone through also. So sometimes somewhere, my lord, in some paragraph it says something, my lord. In some paragraph also, my lord, it says something, my lord. So it's very difficult to distinguish, my lord. But so for the NDPS is concerned, absolutely
No,
clear.
that is clear.
Absolutely clear.
But
There's no
from
doubt about it.
there to extract that Balkishan has been overruled, that is not there.
Not there.
Not there.
Not-
And they have brought out 6 distinctions to fancy
Well,
between the officers doing duty in revenue matters or railway unlawful act matters.
excise,
And Borkotram is excise,
excise,
NDPS.
NDPS,
In NDPS, Enforcement Director, Directorate of Revenue
Revenue.
Intelligence, Customs, Police, they are police under section 25.
Tada, Pota, everything.
Everything. So NDPS officers investigating NDPS cases, they are police officers and their confessional statement is inadmissible.
Well,
That is what has said. Now here, if you see section 9, it says about issuance of summons.
summons. But if you inquiry, my lord, and here, in this case, my lord, your lordship, he,
Have you read Borkotram or not?
what Ram, I, yesterday,
Better you read Borkotram.
what has happened yesterday, I could not get time, my lord.
I could not get time also.
Definitely, somehow, my lord,
Somehow
I also manage regarding, because there's a 200-page judgments, I have to go dissent, what the dissent, judgment setting is there also. So it takes a lot of
initially,
time.
yesterday I also, while reading, I forgot that there was a dissenting judgment. I started reading the dissenting judgment first. So I got confused, more confused.
By Indira Banerjee.
Indira Banerjee.
So,
Very difficult.
Well,
But
honestly,
You
one thing, Milord, when I go through Milord, I also became a confused. Now, in some of the paragraph, Milord, the distinction has been made in a different way, and some of the paragraph distinctions have been made in a different way. So slightly for me, Milord, I became confused. That's all.
why I'm saying so, Mr. Bora, this particular paragraph in Balkishan. Three questions were framed.
Balkrishna, Milord, yes, Milord. This
Three
Bal-
questions were framed,
Yes, Milord.
right?
Yeah.
Paragraph 1 itself.
One, Milord.
Second question. First question is clear.
Whether an officer or so and so. Second is whether person.
Read the first question. Read the first.
Yes, Milord. Whether an officer of the Railway Protection Force making an
Mr.
entry.
Bora.
I'm sorry.
Again.
No, okay, my lord, we'll continue.
I will continue.
So, Balakrishnan, sir, definitely I'll stay on the Balakrishnan. I'll stay.
Balakrishnan.
Tomorrow, my lord, because your lordship will have a lot of cases listed, my lord, it will be very difficult. Subject to convenience of a lordship, my lord.
And I beg apology.
My lord, because it will be the case, my lord, where the High Court has to deal with a legal point on Railway Property Act, my lord.
Huh? See? I don't know whether I'll be sitting in division bench or this bench or that bench next week.
But if your lordship kindly, if your lordship, as and when, my lord, already it is also in our mind also. This Balakrishnan case definitely will has to be.
We just will be aware whether I'll be, because there is